Mic check. In 501, my lord, as we tentatively mentioned before my lord, the Chief Justice, Lord, if your lordships can provide for some schedule of dates, because many things are yet to be filed. We have done our best, my lord, to go as per, my lord, your lordship's formula, which is working very well. But, my lord, written submissions, etc., my lord, everything needs to be.
So now, as you know, we have prepared an SOP,
Yes.
so which we followed in Maharashtra and particularly very beautifully followed in Article 370. And it's an SOP dated 22nd August 2023, which sort of now basically the very same format which we followed. Mr. Dave was there, so attorney and solicitor were there, Mr. Siu Singh was there in Article 370. So if all of you can really prepare a common compilation, because what happens is the SOP has been very useful. Otherwise, our problem, when you are dictating a judgment is, suppose there are 8, 10 lawyers. You have 10 compilations of case law of different lawyers, and it becomes impossible to track each one of those cases. You have to go to, if you have one compilation, it becomes so much easier.
Maybe make a suggestion.
So how do we go about it? How should we give about 2 weeks time for you to prepare the compilation?
One aspect.
But it has already been done.
It is already done?
Yes, in 5 volumes.
Whatever
It's not in the format. It's not in the SOP format.
No, whatever is there, my lord, on our side is brought in the SOP format, but it's not adequate.
Can we suggest one thing? We'll appoint as usual 2 nodal counsel, one from your side, one from the government side.
That is already
done.
Already done.
Now they will ensure that the compilations are brought in conformity with our SOP.
Yes. So
So that once that is done, it will help your convenience also in arguing the matter.
Yes.
So I told the nodal counsel tells me the computers are crashing. The weight of material has been on both sides. Now we need to prune it so that we don't have this problem.
In fact, my lord, the referral order is not part of the compilation. That needs to be incorporated.
All right. Only now one more thing with the sorry.
See your lordships order of 10th of January.
Yes.
Where lordships have appointed nodal lawyers on both sides, my lord, and formulated the question. They have done a good job, my lord. They have made a compilation in that, my lord, but something needs to be added. So lordship may give us 2 weeks time for both the parties, my lord. We will inform the nodal lawyer, and anything to be added, thereafter, my lord, we will file out no submissions.
And written submissions also now in the next 2 weeks, so that
Can it be 3 weeks? Can it be 3
the
weeks?
suggestion is,
It would be
as
real.
far as the documents are concerned, the pleadings and the case law, let that be done within 2 weeks because it is more or less ready. Thereafter, please give us at least 1 week time, if not 2 weeks, because the written submissions have to be cross-referenced to those documents. So therefore, we need that lead time. Once we have those volumes which have the documents volume, etc., then the written submissions can be easily.
Can we not shorten it down to 3 weeks? Because if we say 4 weeks,
all right,
we
fair
are
enough.
on
The 3 plus 1, if your lordships can say.
Lordship may bifurcate it. The common compilation may be prepared within 2 weeks.
Yeah.
Within 2 weeks thereafter, we will file out written submissions giving cross-reference to those.
2 weeks or 1 week? 1 week thereafter, whatever.
File your written submissions within 1 week thereafter, so 2 weeks for the.
3 weeks
3
in
weeks,
all.
yeah,
3 weeks in all.
Weeks on now.
With your lordship's permission, may I just point
It's there in the SOP. It's there in the SOP.
All can cross-reference.
Now, who are the 2 nodal counsel they are here?
Mr. Ayub.
Mr. Goswami is there, and on your side?
And Diksha Rai.
Diksha Rai, my lord.
Sir, I am.
And Fuzel
Ayubi. Mr. Ayubi.
Mr. Ayubi, these are the 2 on our side.
These are good.
So,
There's one thing here. If your lordship see 10.
Just,
for the written
Yes,
submission.
definitely.
It's just that once the common compilation is filed, the juniors will have to just put the pages of the common compilation, that's all. That's all that
I
has to
think
be
3
done.
weeks is good enough. my lord.
10 January order of my lord.
Yes.
has-
In terms of the.
Only one aspect might end. Lord, Mr. Siu Singh is sitting on the center. Mr. Sibal is on the right, but in fact, all of us are on the same side for a change.
In fact,
Right, substantially.
Clarify that, since your lordships on 10 January have narrowed it down to one question. Today, your lordships have said 6A, whether 6A, section 6A is
Valid or not.
In view of that, it's not now petitioner and respondents, it is those who are challenging 6A and those who are supporting 6A. So they might, some of them might be petitioners, some of them might be respondents, but the question now is really, so all
Yes.
of us, Mr. Sibal, me,
We are supporting
Mr. Trivedi, etc., we are all for either interveners or respondents.
So that's the only point before the constitution.
But that's only one point, which is why the solicitor. So it's
My lord, with your lordship's
That's
permission,
on the merit.
the basic thing is, those who are sort of supporting the motion, so to speak, and those who are opposing the motion, we are all on the same side, saying that 6A is validly enacted and within the powers of parliament, and et cetera, et cetera. My learned friend, Mr. Diwan, Mr. Hansaria, and all are representing those who are challenging the validity. So that's the broad.
That's why the solicitor said and named me and saying I'm on the right side.
my lord,
Geographically right side, my lord.
Lord,
It's geographically on the right side.
My lord, there is one request, my lord. I think the lead case has been wrongly shown that Assam public work is not the lead case, my lord. 562 of 2012 is the lead case. The lordship will kindly pass a
That has
special
been
order to
made
that
very
effect.
So what we'll do is we'll say in re
In
section
Ray,
6A
yes,
of the.
yes, yes.
That should be the common, I think.
out with the
SLE, just 1 second, 1 second.
Saying can be the
Procedural directions
Yes,
are
yes.
issued, procedural directions have already been issued
Ah,
on 10 January 2023. Full stop. The title of the proceeding shall be,
in rain.
as agreed, next line, into invert commas, in re, section 6A of the Citizenship Act 1955. Next. The nodal council, the nodal council appointed by the previous order have prepared a common compilation. Full stop. However, the common compilation needs to be brought in conformity with the circular which was issued by the circular which was issued on 22 August 2023 to streamline the filing of soft copies of common compilation, particularly in matters before the constitution benches of this court. Full stop. The nodal council shall now take steps to ensure that the common compilations are brought in conformity with the circular, and a common index is accordingly prepared for that purpose as well. Full stop. The common compilations shall be, soft copies of the common compilations shall be prepared on or before, after 2 weeks, within 2 weeks, and full stop. Written submissions shall be filed on or before एक सप्ताह or extend सकते हैं.
It shall also be
So
filed.
the common compilation will be filed on or before 3rd October, and written submissions on or before 10th October.
My lord, I wish to point out one little thing.
Those who are challenging 6A.
By
1
the
second.
order, just give me a second.
That is already known.
It has been agreed that the contesting party shall consist of those who are challenging the constitutional validity of Section 6A of the Citizenship Act 1955 on one hand, and those who are those including the Union of India who are supporting
In the state of Assam.
and the Union of India and the state of
Some
Assam
of the case
who are
section.
supporting the validity of the provision.
My lord, I wish to point out that this reference,
Common compilations shall accordingly be prepared, bifurcating the submissions, bifurcating those who seek to impugn the validity of the provision, and on the other hand, those who support the provision.
my lord, may I just make a point? My lord, your lordship may be aware that this reference has been narrowed down from the original terms to one order of reference only, and that is whether Section 6A of the Citizenship Act suffers from any constitutional infirmity by order dated 14th February 2023. Therefore, while making the compilation, my lord, counsel should be aware that their materials must be confined only to this one issue, my lord. Otherwise, the hearing will become
That's
very.
exactly what is.
There can't be.
If we get into history.
Referral order contains 13
Sole
points of
order of
reference.
reference. This is the sole order of reference.
In fact, on an earlier occasion,
common
Lordship was
compilation.
to grant us leave to ask all the points.
The common compilation and the written submissions shall be confined to the issue which is.
Lordship,
See that.
no, Lordship
It
will
will have to
recollect.
be, my lord, it will have to.
No, 1 second. Lordship would recollect on an earlier occasion, this question did crop up, my lord, when we say the referral bench refer 13 issues. Therefore, Lordship was pleased to observe that they can argue all the points.
Yes.
Where's the question of bogging down us?
Right,
That
what we do.
question has several facets.
Yeah.
Right, we will now not say anything on that.
Yes.
But everybody is now, we have already we have clarified
correct,
that
Your
the
Lordship.
issue is whether section 6A is valid. That's the issue.
It's the only issue that is referred now, my lord.
Dates now,
The date for the hearing may
Date
be.
for the hearing.
So
Lordship.
now, the entire exercise will be completed on the 10th. Should we start on the 17th?
Yes, very.
Yes.
17th of.
October.
October?
Lord, can
Yeah,
you,
there will be a vacation
Or
immediately.
otherwise we have to start on the,
Post Diwali, my lord.
post Diwali, my lord, if it can be
Diwali will be a little.
November, my lord, it can be in
The
November. There
problem
would
with
be
Diwali
some-
will be then it will be pushing it back.
21st of November.
No.
From the 17th to the 20th of October, you have 3 days, my lords. This is not a matter which will conclude that way.
Safest is after 19th of November.
No. It will be too late.
There are holidays, this is what do you do?
No. It can't be. Let it be 17th
It
of
might be a
October, my lord.
truncated hearing
17th
after
October.
9th
Let it be
November.
17th of October.
Yes. It's a matter of 2012.
There are only 2 working days, my lords. 20th would be a miscellaneous day in
So
October.
if we start on the 17th, you get 17th, 18th and 19th of October.
Correct.
Can't
There'll be a break.
It can't be over, my lord.
It won't be over, my lord.
Realistically, it can't be over.
And
but there'll be a
specifically if
break
your
and
lordship
then
is
there'll
Right, but it's only a 1 week break.
Yes.
We can resume
And
again
then we'll
on
resume immediately after the break.
31st again, we will start.
Yes, correct. That's right.
That will also give parties on both sides a little time to
Yes.
prepare once the matter has been opened.
Absolutely.
Grateful.
Absolutely.
17th?
Yes, very well.
17th of October, my lord.
Yeah.
My lord, there is no difficulty, my lord, but otherwise, my lord, considering the intervening holidays,
it will also give us time
to focus, my lord, if it can be in the November after Diwali.
Let's start on the 17th.
Yes,
What
yes,
happens
yes.
is, that after Diwali, then at least we get started, once the matter opens, then we know we are in season of
Yes,
it. And
correct.
then, otherwise, and this side will be arguing, I guess, for those
That's
2
right.
days or 3 days. So you'll have enough time until after the Shera to prepare.
The idea was.
Good food for thought during Diwali.
Yeah.
I don't know about lasting till Diwali, but certainly we'll last for that first week till the Dussehra break. We will definitely take on our side.
Yes.
Yeah.
I think it starts the 17th. The 17th.
I'm grateful.
Or, my lord, other alternative is 31st.
After the
Well,
Dussehra.
let's not quibble. I leave it,
All right, we'll start on the 17th. So that we at
Wait,
least,
wait.
we have a flavor of the matter when it opens.
Yes.
We'll also have the week to do our own little reading, etc. And that's better. So in fact, what I'll perhaps do is all the other constitution benches, because it's like a permanent constitution bench. We will progressively, we'll be listing all matters for direction so that then everybody gets a little time to prepare their compilation. So at least the matters are ready for hearing.
When it is listed, yes.
Whenever
that's
they're
right.
ready. There's 7 judge, 9 judge matters. We'll also do that exercise so that, everybody gets enough time. Then we can space out the hearings later. There's no difficulty.
Very well.
Good.
And it was, it was so streamlined because everything was in just one set of compilation. It becomes very simple to, for everyone on both sides to argue actually.
Passages in judgments and all, you can't mark it in multiple volumes. That then pops up in this way, there was only one copy of each judgment.
Well, this SOP has worked, my lord, really effectively well, my lord, really effective.
So we'll,
Please.
all.
Mal-
Same set of lawyers in 502 or different set of lawyers in 502?
In 501.
My lord, the lead
intervention
case-
which your lordship had on an earlier occasion permitted me to file. That intervention may be formally allowed. I'll just give the number.
We'll hear you what. We have allowed interventions, right?
I'll give the number to the court master.
Sorry.
Right.
All submission, my lords. Item 501, it may not be detagged, my lords, from the list, my lords.
They're not detagging anything right now.
Item 502.
Please, Your Lordship. My Lords, one development which we did make was learned attorney and I were able to arrive at 7 broad issues. I mean, there are a lot of arguments which will come up, but we came up with 7 broad issues which will arise in this case. And would Your Lordships consider, otherwise we have to come back to the same scheduling, my Lords, and following Your Lordship's SOP. The timelines we can agree on, because I don't think we should take more than 3 weeks to be ready, 2 weeks to be completely ready.
We have the same problem of having our documentation complete.
Sorry, I can't hear you.
As we went through the issue, sometimes
Mr. Sundaram was not able to hear what you said.
unless we have the documentation part completed. And then sometimes we have an issue frame and we have some materials to be read. Some fine tuning, a precision of an issue also happens. So therefore, I think we should.
In fact,
There are 4 more issues, your lordship, which we have raised, your lordship. I have in the transfer petition.
May I, just 1 minute. May I say this,
Yes.
my Lords? It was
Yes.
because of this, the documentation, everything else, because especially this issue becomes historical, otherwise it goes on, my Lords, as to, we go back to even prior to the Constituent Assembly. So the point here, my Lords, was because of that, we thought we would draft the issues which we felt would arise. So our documentation can thereafter be centered around those issues.
Change the issues which.
Yes, we
proposed in
have.
the court.
Learned attorney and
There are 4
I,
more issues which we have raised.
just 1
One
minute,
second,
1 minute.
1 second, step by step.
Hand over the issues which
My lords,
we had thought.
I am sorry to say that I have some different issues, my lords. I tried to mail
One
them.
second, 1 second. Let him place the issues which he wants us to look at. We're not going to suddenly dictate an order without hearing everybody.
My Lords, these are broad within it, because if we go into sub-issues, we'll come to 21 issues. So what we thought was we just brought 7 issues which would arise in this matter.
Would you like to read it out?
Yes, my Lords. Whether the proposition that, sorry, I have my Lords got it. Whether the proposition that reservation of seats for the scheduled caste, scheduled tribes in this Lok Sabha and their state legislative assemblies cease after a certain period, can it be said to be constitutionally final? Whether the right to stand as a candidate or to vote for a candidate in direct elections to the lower house of parliament as well as the legislative assemblies from all walks of society is an integral part of principle of equality and democracy, and as such a part of the basic structure of the constitution. My Lords, in fact, this would be the major issue, because it would then decide how the matter is to be decided, whether it's part of the basic structure or not. This would be the major issue. Whether the amendments to Article 334 of the Constitution, extending the period of reservations, are not subject to closer judicial review in view of a limited reservation policy enshrined in the original Constitution, whether objective and quantifiable data was present for such extensions to save them from manifest arbitrariness and the requirements of Article 14, whether the Constitution 104th Amendment Act is therefore unconstitutional, and whether consequently all provisions contained in any enactment for which provide for or facilitate such reservation of seats in the Lok Sabha and state legislative assemblies, and various examples are given, my Lords, will thus become constitutionally invalid, because the direct effect is on these specific statutes. Given the language of Article 329A, the original base provision of the Constitution, whether it can be said to be in violation of the basic structure of the Constitution by taking away judicial review of challenge to delimitation of constituencies or allotment of seats to them under Articles 327 and 328. Whether distribution of number of seats. Now, my Lords, if your Lordships say that it can be continued and decide against us on the other issues, then another issue would arise is whether the distribution of number of seats for the SC and ST without rotation is violative of Article 14. And whether the Delimitation Act is violative of Articles 81, 82, 170 of the Constitution. My Lords, it is my belief that a lot of subsidiary issues will arise out of this. A play of 19(1)(a), play of 14 with that, play of 15, 16. But this would be broadly, all that I feel would be covered when your Lordships are considering issue number 2. And I feel this more or less, what we did, my Lords, is when we went into specific issues given by everyone, we ran into, we did a compilation of issues.
Mr. Attorney, I'll just come to you in a moment. Just 1 second, Mr. Attorney. Mr. Aruneshwar Gupta's 4 issues are all subsumed in Mr. Sundaram's formulation.
Yeah, but
I think Because Aruneshwar, Mr. Aruneshwar, your issues are submissions actually. These are not issues. They're all subsumed.
In my issue is-
Just one second, Mr. Attorney, have you been able to, are you
In
agreeing?
fact, we shared some issues earlier. I think on a relook at it. I think issue number 4 is the only issue which requires to be considered. The rest are all upon satellite issues.
Let us
Whether
see
the
again.
constitution is therefore
Can we
unconstitutional.
read
That's
the-
the
Arguments on fourth issue.
right. That's the only direct issue to be
Well,
considered.
that is a very wide format. But to arrive at the conclusion for 4, I feel a decision under 2 is vital, my lord, whether it's basic structure or not.
So therefore, issue number 4, the first part of it is a direct issue to be considered. And even number 6 may not arise here at all. So then,
It would be for different facets of.
call the satellite.
These are arguments. Submissions or.
Make a submission. I agree with the AG. The central issue is 334. This should be called in re 334. The 334 proviso is what we're challenging, the 10-year extension. Everything else is consequential. Many of the other issues are consequential.
They're really
As far as-
arguments under different.
Exactly. As far as the Constitution bench is concerned, the constitutionality of the 334 proviso has to be looked at. The rotation issue is only if we, that doesn't necessarily have to be dealt with by a constitution bench, that could be even dealt with.
Can we just look at the provisos that are, let's read it for a moment before we formulate constitution दे दो. दूसरा वाला क्या आ गया वो?
Can I have that?
Of that, Manoj,
That'll be nice, because that was very useful actually.
that's the old problem. 334, Manoj.
Just read.
Notwithstanding anything in the foregoing provisions of this part, the provisions of this constitution relating to A, reservation of seats for the SCs and STs in the House of People and in the legislative assemblies of the states, and B, representation of the Anglo-Indian community in the House of People and in the legislative assemblies of the states by nominees, shall cease to have effect on the expiration of a period of, and this is where the amendments have come.
Every
80
10 years.
in respect of clause A, so that continues, and 70 years in respect of clause B, therefore Anglo-Indian has come to an end from the commencement of this constitution, provided that nothing in this article shall affect any representation in the House of People or Legislative Assembly until the dissolution of the then existing House of Assembly as the case may be.
So Anglo-Indians, it has come to an
That's
end
come
in
to an end.
2020.
That's come
So
to
we are
an
now left with really the challenge to
My lords,
SC/ST.
in fact, the issue is, my lords, every
it.
10 years,
Therefore,
the
we
proviso is being amended. Every 10 years, the proviso is being amended. For example, now it is 80 years, earlier, 10 years ago, it was 70 years, before that it was 60 years. So the present amendment is, this last amendment was saying 80 years. Earlier, the amendment, if your lordship would kindly see, it replaced the 70 years which was there earlier. So every time the period is expiring,
So, Mr. Sundaram, your argument in issue number 2, I'm just to understand your argument, is that by reserving certain seats for a certain community or a group of communities, that affects the rights of other communities to contest for those seats, and this is a part of the basic structure.
A.
That's your argument.
absolutely, my lords.
But this is a submission.
My lord, that is one.
So the question
My lords,
is challenge.
I have no I just tried to highlight this. If your lordships feel it can be all dealt with in one
So
issue,
what
I
you
have.
know is when you open the arguments, you can say that your challenge
These
is
are the
going to be
propositions.
on the following grounds, which
My
we
lord,
will of
because
course-
obviously the other issue which I did not include was the nature of temporary legislations, etc., which again is a matter of argument,
That's a matter
completely.
of argument completely. So really speaking, we should frame the issue in terms of 4 as a
First part of
solicitor says.
four,
Part of four, because third is all. the second
Then, my
part
lords,
is also
everything will be subsumed in it. Everything will be subsumed in 4.
That's what the learned AG is suggesting.
No, I have no problem on that at all,
Whether
my
the
lords. I have,
Constitution 104th Amendment Act is therefore unconstitutional, and whether consequently all provisions
That will
contained.
take care of everything.
It's an umbrella issue which takes care of other propositions.
The,
With Lordship kindly, my Lord, may I make one submission, Lord?
yes,
Lord, I would request, my Lord, 2 or 3 issues to be added, my Lord. Lord, I have also, my Lord, given the issues, my Lord, to the Nodal Council, but unfortunately, my Lord, it is not there. I leave it to my
who
Lord.
has the issues, Mr. Chandrachud?
I will leave to my Lord.
Chandrachud, 1 second. Just give us who has the issues which you are proposing. You have them. Just give
Yes,
them.
my Lord, it is.
Just 1 second, Mr. Chandrachud. We'll just get it circulated to us. Very good.
No, do you have a hard copy for their lordships?
You have mailed it. When did you mail it?
May I submit, my Lord?
Just now, then. All right. What are the issues? You tell us, Mr. Chandrachud.
Whether political reservation in the absence of protective reservation under Part 3, protective discrimination under Part 3.
1 second. He'll just take more printouts for all the colleagues. 1 second. और अपलोड भी करो जरा, so that all the other lawyers will also get it. अपलोड कर दीजिए, इनको एक दे दीजिए अपलोड करने के लिए. I'll show you. Our paperless process will be very interested to see how. वो अपलोड कर दो. ठीक है, everything on the screen, no?
I think the same. These would be various arguments under the same issue.
These are again submissions and proposals.
This becomes argumentative again to substantiate the main issue.
All right. Let's read it. Whether providing political reservation valid in the absence of protective discipline, whether providing political reservation violates fundamental rights, national in the future. Has particular prevent a citizen in any constituency reserve the right of constitutional women. Void by the constitution. Arguments, actually. These are arguments.
It's again, once your lordship says.
Comprehensive enough to cover.
If your lordship say 4 is the umbrella, then even my other issues will fall within 4. I've just maybe perhaps subdivided.
First part.
The following issue is framed for decision by the Constitution Bench, whether the Constitution, bracket 104th Amendment, bracket Act 2019, is unconstitutional.
My lords,
That's it. I think that's not.
my lords, I was just wondering, subject to what your lordship say, the 104th Amendment is an amendment. Before that, there was an earlier amendment for the 70 years, 60 years. So perhaps the umbrella issue would be whether constitutional amendments extending periods of reservation under the proviso. No, not in the past, not in the past. I'm saying 104th, your lordship is then limiting it to 10-year period. I'm not asking your lordships to go behind the 10-year period. I'm asking my lords to, whatever your lordships will decide to be forward after the 10-year period also. Because the 104th amendment may be replaced by a subsequent amendment 10 years later.
To go back in point
So
of time.
all I'm saying is the principle is what is the major issue which has to be decided. Otherwise, my lords, I'm not going behind the 104th amendment. But the point is, if your lordship say 104th amendment is bad, then there might be a subsequent amendment after 10 years for another 10 years. So your lordships have to see whether
This will take care, or if you want, we
the
can.
concept of extending the reservation.
Should we formulate them? We have just lay low, but we'll just say whether we should include it. Whether the exercise of the constituent power of amendment to extend the period prescribed for the expiration of the period of reservations under Article 334 of the Constitution is constitutionally valid. If you want, Mr. Aryam, Learned Senior Counsel, full stop. Issue 2, it is clarified, shall not impinge on the legitimacy of the amendments to the Constitution which were made prior to the 104th Amendment.
My lords.
that 104th amendment to the extent it applies to SC/STs, because the amendment applies to Anglo-Indians as well.
All right.
The way probably I was looking.
It is the validity of the 104th amendment shall be determined to the extent that it applies to the scheduled castes and scheduled tribes only.
Yeah.
Since the reservation for Anglo-Indians in Article 334 bracket B has come to an end on the expiration of 70 years after the adoption of the Constitution.
My lords.
All this in Re 334.
The reference to the Constitution bench.
That again, my lord, is an argument.
No, we'll just say, no, title.
That's right, your lordship will say in re.
The reference to the Constitution bench shall be titled as in re Article 334 of the Constitution.
My lords.
Now, we will say in terms of the SOP dated, the circular dated 22 August 2023, who are the two nodal council?
What I have done is, in terms of the SOP, I have prepared a Google form and I have circulated among the lawyers. For the purpose they can upload it on the form and it can automatically come in. So let's, I am Manoj.
Singh.
Chitwan single would be on our side.
Now, who on your side?
Chitwan single, my lord, he would be the
Mr.
Chitwan
single.
Single, my lord. Because we would also like to place material on record.
And fair enough.
My lord, strengthen.
On
our
your
case
side,
that the reservation can go on.
The common compilation of case law, documents and written submissions shall be prepared in terms of the circular dated 22 August 2023. Let's stop. In modification of the procedural directions issued on 1 November 2022, Mr. Puneet Jain and Mr. Chitwan Singh, Mr. Puneet Jain on the side of the petitioners and Mr. Chitwan Singhal on the side of the respondents are appointed as nodal counsel. The nodal counsel shall prepare soft copies of the common compilation duly indexed in terms of the above circular. Full stop. This exercise shall be the common compilation of documents, including statutes, shall be filed within a period of 2 weeks. Within a period of
4 weeks, my lord, your lordship.
3 weeks, I think.
We'll be common in Assam also.
We do our personal research.
All right, within a period of 4 weeks, within a period of, on or before, aisa kar lo, on or before, today is the 20th, right? 27th October, on or before 17 October 2023, the written submissions shall be filed on or before 7 November 2023. The proceeding shall be listed before the Constitution bench on 21 November 2023. I think 21st we'll have finished in that time we'll finish Assam.
Right. Yes, because that will take time.
There are some interventions.
I don't know.
Motor Vehicles Act is on the 22nd, is it?
21st.
When is that, Mr. Chitwan?
21st of November.
Oh, we have kept Motor Vehicles Act on the 21st, but Motor Vehicles Act, we don't know whether you will be ready with your.
We take about an hour or so.
So we'll take up this after then we can take it up on the 22nd instead of 21st. So that let Motor Vehicles Act, because that we have heard arguments now is that the government has to tell us what they want to do.
22nd.
So 22nd, whether we'll keep it, I think, Brother Bopanna, 22nd is okay, no? आप एक ऐसा कर लो मेरे लिए. You can prepare for all 5 of us the constitution benches and dates, so we know, So my learned brothers also presiding judges on their benches, they'll also know what matters not to fix. You can tell their court masters also, so that they
There are some interventions, Your Lordship, allowing.
Interveners can be heard, my lord. It need not be.
But otherwise it increases the pleadings if they're
Pleadings,
pleaded.
etc.
Let them just be heard, my lords.
The interveners will be given an appropriate time slot for the purpose of the arguments. Full stop. Next, you say all the learned counsel on behalf of the petitioners and how long would you take? Give a one.
I would say about 3 days, my lords, I would take.
All of you.
I'll try to finish in 2. I'll spill over to the 3rd possibly, my lords. But the rest, I think,
All right, but at the beginning of the hearing, we may not.
I don't think everybody else will take more than a day.
All the learned counsel appearing on behalf of the petitioners, including the interveners, and the learned counsel appearing on behalf of the respondent, shall provide to the court a statement of the tentative time limit within which they seek to complete their respective arguments. Then we will fix time as we did in the earlier matter. Otherwise, we just get repetition. So that we also suggest that all the learned counsel for the petitioners and the respondents, you have a meeting between yourselves and petitioners so that you can bifurcate who is going to argue what issues. After the first 2 counsel have argued for the others, you can supplement. Then it will be much easier for us as well. If something has some nuances remained, of course you can add to the nuance, but otherwise it doesn't get. Otherwise, we felt, there's no secret that, Mr. Shankaran at the end, who had done all the hard work, got the least amount of time in the previous matter.
He got 2 hours.
He got 2 hours in the original, but in the rejoinder, nothing at all because.
So I have the pleasure of hosting this meeting.
Attorney is going to host the meeting for all of you. He'll also give you some nice snacks as well.
Yeah, learned attorney is a very good host also.
Very good.
Grateful.
Should we keep it on? That's only motor vehicles, no? Kept that motor vehicles thing on the 22nd. Arbitration, what's your genuine assessment? Arbitration will be ready to go on by then, or you think that committee will be still?
Committee has given us report, but I think there is some more
development. So that may or may not go on.
Yes.
Then motor vehicles will be.
It's only a report giving exercise.
Motor vehicles.
Yes.
So I think we can keep it on the 21st. Then let's see, we can.
Probably those 2 matters.
On 22nd, we can take this after lunch or something like that because it zyada nahi chalega. We'll start on the 21st, I think.
In case I can probably in advance assist the court by bringing those reports and their any further.
In case you are ready, let us know. We can list motor vehicles on the 21st.
Yes.
So motor vehicles will get over in say an hour or so, and we can start this on the afternoon of the 21st. So that
I'll get it.
Today we'll keep it on the 21st. At the worst, we'll have to break this for maybe half an hour or so on the 21st.
We'll try to avoid that.
If you can avoid that.
We'll try to.
I think that's better.
It is November.
Connected matters would follow, my lord. Otherwise, my lord, this would be never ending. Mr. Biju's.
You argue. Forget the matters. We are not going to look at the individual pleadings. We have the question of law which is required. We will hear you. We will hear you. There's no difficulty. I put all the connected matters. We will just ask.
Lordship.
Obliged.
He'll specifically enforce it, my lord.
All right. 503.
In 503, we have the learned amicus here, and I am ready with the matter. But only thing is, even though compilations have been filed on behalf of the amicus, I didn't have that done from my part.
For the petitioner, I wish to say something. For the appellant.
Mr. Ramchandran, you are for the appellant. Are you all ready? Then we can start something. We have assembled our benches are not.
And I am going to try to persuade my lords that this reference was not necessary at all in the first place, and that the matter needs to be heard by a regular division bench. Because compilations and all, which the learned Attorney General wishes to file, your lordship may decide after hearing me on whether the reference itself was necessary or not.
I think
Because
we are
according to
right
me,
about that.
on the basis of the facts of the case and on the orders passed themselves, a reference is not warranted. I'll just place that before my lord.
Not in fact what happened on the last day also. I had the next matter, Article 319, I was in court. So both the sides were saying that perhaps reference. Then court felt that we want correctness of the decision in PV Narasimha Rao. So that is what they asked me to assist the court as to whether Narasimha Rao, according to me, is correctly decided or needs a fresh look by a larger. So that's the scope of my assistance to your lordship's court. So I am ready with that. According to me, it does need a fresh, is my respectful submission.
But the occasion has not yet arisen, according to me. I'll persuade my lords.
Then we can really open on that actually because.
Even I said there's no need for a reconsideration of Narasimha Rao.
Because I'm for an intervener, I support Mr. Patwalia 100%. There's no question of a bribe giver. By insulated in some way when the bribe taker is made a vote in parliament.
And a person who takes the right to vote and does not vote, as per Narasimha Rao, is capable of being prosecuted. But a person who does vote then becomes immune from prosecution, as per the majority in that judgment. I have made some points for your lordship's consideration, not in my written submission. So I can support you.
I only want to add this, that the law throughout, whether in UK or USA, the proceedings in parliament is a core issue. Your speech or vote must relate to the proceedings in parliament and the function of the business in parliament. Something unconnected with it is not protected at all. Sita Soren falls in that category. So election to Rajya Sabha is something unconnected with the proceedings, the business of the house. Therefore, the larger reference may not be necessary at all, but I think appeal
All
may be
right,
necessary.
then we can actually start because instead of just placing it some other day, we can at least hear Mr. Ramakrishnan on this, I think, and Mr. Patwalia is also ready. If we decide to enter upon the reference, then of course we'll be hearing Mr. Patwalia.
Correct.
Only assistance is, of course, I can place all some articles and judgments from.
Because
US
the attorney's
I
written
can place
submissions
on
are not on the record. I was asking
That's right.
Mr. Gaurav Agarwal even yesterday from their side, nothing has, as per the SOP, nothing has.
Amicus's submissions we received, my lord, yesterday.
Yes, but because the matter came up, so
I'm not blaming, I'm not complaining.
So
Actually,
really, as per the SOP, I'm ready to go on. My submissions are there. And
Lordship may start the matter. I think the question of
The
whether it
attorney
should be
let the parties first address and intervener may like to start, but our submissions, judgments, etc. should be under.
But the learned attorney has given some articles.
Today we are on Wednesday.
But the learned attorney has given some articles in really speaking as to what amounts to a proceeding in parliament. Now, I have not looked into that issue because I didn't know they would be coming up with that. So, I mean, if they are going to say that voting at an election for a Rajya Sabha member is not a proceeding in parliament, then there is an earlier full bench in Kuldeep Nair, where your lordships have held in para 373 that yes, it is not. If that is not, then his petition has to fail straight away on that, because then there's no question of immunity if it's not a proceeding in parliament at all. But if that issue also is to be raised, then, my lord, I have only been appraised of that today morning, in fact, at about 10:30, that those articles. So some reaction time, if they file it, then I can have. But on the question whether on a pure legal submission, whether that judgment needs a fresh look, there is no doubt in my mind that the judgment needs a fresh. But
That's
fine. That's fine.
But we are not dealing with an abstract situation.
The judgment is very interesting.
But we are not dealing with an academic debate, minutes, on whether this is right or wrong. The question is whether a reference to 5 judges on whether Narasimha Rao should be reconsidered, in which case 7 judges, whether all that is warranted on the facts of this case and on the judicial orders of this case. That's the question, not generally whether Narasimha Rao is a good judgment or a bad.
Then, Lord, I suggest what can be done is let them file those articles because they are both together on that. And we have been confronted with that only today morning. So let them file that and let us have some reaction time on that.
It is.
Just show me. Okay. Just show me.
is subject of codification still eludes almost several.
This would have ramifications.
Another-
Our house also be completely in order.
Mr. Ramchandran, once the reference has been made, we should hear the reference.
Another
And, ultimately, these are important matters. It's so difficult otherwise for constitution benches to reference, assembling, then it goes into the loop for its own order for hearing. Now that we have the reference, we should hear the matter.
Please see only two orders, my lords. And then if your lordship still feel it's necessary, your lordship may go ahead. Just two orders of this honorable court in this case. Just two orders. In volume 3, pleadings, the record of proceedings. And just 2 lines on what this appeal is about. The appellant, my lords, may I just give 2 lines of introduction to the merits of the case as to how this appeal came to be filed.
Yes.
The appellant, my lords, was at the relevant time an MLA of the Jharkhand Legislative Assembly belonging to the Jharkhand Mukti Morcha. She was sought to be prosecuted for allegedly receiving a bribe from an independent candidate, not her own party candidate, for an election to the Rajya Sabha. There were 2 Rajya Sabha seats to be filled. MLAs were voting. She, as a voter MLA, is alleged to have received a bribe. She was sought to be prosecuted. The appellant moved the Jharkhand High Court for quashing, claiming the protection of Millard's Article 194(2) on the ground that Narasimha Rao has delineated the scope and she is immune in respect of any vote given, irrespective of whether she actually voted for that person or ultimately did not, as it happens in this case, she didn't ultimately vote for that alleged bribe giver. The High Court decided against my client, holding that since she did not in fact vote for the bribe giver, but voted for someone else, she is on the same footing as Ajit Singh in Narasimha Rao's case, because Ajit Singh in Narasimha Rao's case did not get the benefit of immunity because he did not vote in the confidence motion. He abstained. So Narasimha Rao itself held that immunity is only in respect of a vote given, a speech made or a vote given. Since he did not vote, therefore, he is not immune. That was Narasimha Rao's case. Ajit Singh was liable to be prosecuted. The High Court says in our present case that if Ajit Singh is not immune for prosecution because he abstained, equally, my client would not be immune for prosecution because she did not vote for the bribe giver, but colloquially, she ditched him and voted for somebody else. So we are in appeal against that judgment. So that is a regular criminal appeal, which only involves the application of Narasimha Rao. It only involves the application of Narasimha Rao. Now, my lords, when that came up before this honorable court, the first order, I'm just drawing attention to 2 orders. Page 12, my lords, PDF of the pleadings volume 3. That's the record of proceedings, which contains all the orders of this honorable court. Do my lords have it, please? This is order dated 23/9. Yes, my lords. 2 learned judges, my lords. Pleadings are complete since the issue arises for consideration, is substantial and of general public importance. Issue that arises should be We refer these matters to a larger bench of 3 honorable judges to be constituted by Honorable Chief Justice of India. The petitioner shall be free to press his application for ad interim stay before the larger bench. The issue which arises, which is in the appeal, nothing else is articulated here. Because whether Narasimha Rao ratio of Ajit Singh can be extended to my client itself is an issue of importance, which merited a 3-judge bench reference. I'm not quarreling with that at all. When the matter then came up before a bench of 3 honorable judges, now PDF at page 4. Do my lords have it? It's a detailed order. 7th of March, 2019.
Type 4 there and press enter. Leave granted.
Leave granted. The criminal prosecution launched against the appellant is sought to be nullified on a claim of immunity under Article 194(2) of the Constitution of India. The gravamen of the charge against the appellant is that she had accepted a bribe to vote in favor of a particular candidate in the Rajya Sabha election that was held sometime in 2012 in Jharkhand. The precise question was dealt with by a 5-judges bench of this court in PV Narasimha Rao. While 2 judges of the bench took the view that the protection under Article 105(2)/194(2) of the Constitution and the immunity granted cannot extend to cases where bribery for making a speech or vote in a particular manner in the House is alleged, the majority view, while acutely conscious of the seriousness of the offense, felt that the wrongful act and the sense of indignation, the same thing which is being expressed now also by Mr. Shankar Narayanan, of the bench should not lead to a narrow construction of the constitutional provisions, which may have the effect of impairing the guarantee to effective parliamentary participation and debate. Having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts raised and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench as may be considered appropriate to hear and decide the issue arising. We order accordingly. Now, kindly just these one sentence, having considered the matter, para 5 only, I wish to emphasize, the matter, we are of the view that having regard to the wide ramification, of course, a matter like this of bribery, alleged bribery of an MLA will always have ramifications. The doubts raised, I pause here, where have the doubts been raised? By which judicial order? The doubt has only been raised in the dissenting judgment. If that constitutes doubt raised, then in every case, where there's a dissenting judgment, there's sufficient ground for reconsideration because a doubt has been raised. So the doubt raised cannot refer to the dissenting judgment of that very case.
Is, having regard to the ramifications of the question that has arisen.
Lordship, please.
And the doubts raised and the issue being a matter of substantial public importance. The court felt that this requires consideration by a larger bench in that sense.
But the question still remains, where is the articulation by a judicial order? Neither side has questioned Narasimha Rao. Judicially, there is no articulation of a doubt that Narasimha Rao There is just one more thing I wish to point out, apart from these 2 orders.
But how do you stand in relation to Narasimha Rao? Narasimha Rao will apply to you according to you and you will be protected by Narasimha Rao?
I will be protected because according to me...
But then that's the point. Therefore,
that's a matter of...
Therefore, you apply Narasimha Rao's dictum and allow my appeal and set aside the impugned order of the High Court.
That's right. So that's a matter for 3 judges, not for 5 judges.
No, but therefore, the correctness of the judgment of the majority is squarely something which arises here.
With respect, Milords, in any case with regard to application, for instance, what is
You may be right to this limited extent that if we decide to refer Narasimha Rao to a bench of 7, we may have to formulate some reasons why we are doing that. We may have to formulate some, though of course Chief Justice Gogoi's referring order says reference to of the matter to a larger bench as may be considered appropriate. It could have been well placed before 7 directly. It's been placed today before 5. We may have to formulate some reasons why we feel that Narasimha Rao requires reconsideration.
There is just one more aspect, Blitz. My Lord, the Chief Justice was a party to 2 decisions where Narasimha Rao was cited. One was the Standing Committee resolutions matter minutes, Kalpana Mehta, where my Lord, in one of the judgments, concurring judgments with the majority, observed that correctness of Narasimha Rao is not involved in this case. If it is questioned in some appropriate case, it will have to be considered. Thereafter, in the Kerala Legislative Assembly case, K. Ajit, Narasimha Rao was directly cited and was invoked by the accused. And your Lordship clarified Narasimha Rao, narrowed it to the most narrow interpretation possible, that it can't apply to vandalism, etc.
That was the
Your
case
freedom of
where
expression
they broke furniture in the Legislative Assembly, etc. Yes.
So if free speech and freedom of expression extend to breaking of furniture that is not protected, your Lordship clarified. Even in that judgment, an occasion did not arise for this court to doubt Narasimha Rao. Therefore, on this tenuous one sentence, my lords, is it sufficient for your lordships to spend judicial time? Is my respectful submission. I leave it to your lordships.
Mr. Patwalia,
Mr. Attorney. I concur with Mr. Ramachandran on this question. No need for a reference to a larger bench. The 3 judgments of the lordships which clarify the position that what exactly would qualify for a 194 protection. It must be proceeding the business or the function of the House. So whether Narasimha Rao need to be reconsidered does not arise in the facts of this case at all.
That's right.
A bribe given outside for voting in favor of the candidate or against for the council of election to the council of states. So it has nothing to do with the business or the function or the worker or the legislative work of the assembly. So that's why the US examples make it very clear.
The bribe is given to so that the discharge of functions of a member of parliament or state legislative assembly should take place in a particular way, in accordance with the bribe giver's intent. Is that not related to the...
It was a case of a no confidence motion in the parliament.
Right.
Therefore, anything which is relatable directly or even indirectly, for instance, a number of cases where members are asked to make preparation for the purpose of their legislative business. They may have an excess with that. But where this has nothing to do with that, it's an election pure and simple, a process regulated by set of rules or regulations.
And here, what is the allegation? Where was the bribe given in this case? What is the allegation in our case here?
For the purpose of election to the Rajya Sabha.
Right.
So she received the bribe. That's nothing to do with the business of the House. The function, the legislative act, they call it. In US, almost all the running theme is it must have a nexus with the legislative deliberation or the legislative purpose or the legislative business. So there's nothing to do with that.
That is the stand on merits which we are contesting.
Mr. Patwalia, what do you have to say? Let's see what Mr. Patwalia.
I have my one brief note before.
Let's see what the attorney's noted.
Your Lordship have it?
They'll just circulate it.
Yes.
Milja?
No? And what I have argued is also articulated in my written submission. In the first part of my written submission, I have set out exactly what I stated before, my lords.
Where are your written submissions? Are they in a separate compilation?
Lordship, please, lords. There is volume 1. Volume 1 is my written submission. So, my lords, from the content itself, your lordship will see A and B deal with the same question words. I have only orally articulated what I have stated here.
Where would we get it in your written submission?
Yes, once. Kindly see.
Let's just see first the attorney's written submission.
Very long. I just open I have. The case on hand, on facts not being similar or parallel to the case of so-and-so, the need for reconsideration or similar dictum does not arise. There is no conflict of views. Even if Narasimha judgment has to be read for the purpose of its possible application to the case on hand, it is subject to the context of Narasimha being a matter relating to proceeding in the course of the business of the House. A no confidence motion to be dealt with the collective body of the House. Its application to cases where the context is not of the business proceeding, the functions of the House will not arise, and the protection of Article 194(2) will not be available. The width of protection available to members of Parliament or state legislature in regard to speeches made in the House or vote tendered in the House will depend upon the core question as to whether the speeches of the vote are in relation to the powers, functions, or the business of the legislative bodies. It is submitted that the process of election to the Council of States is not a matter of business or function or work of the House. It is regulated by rules and procedures to be supervised by the competent authority. So I place reliance on these two. In fact, three more judgments I draw your Lord's attention to it now. The conduct in question, which is the subject matter of prosecution, does not relate to the function so-and-so. Casting a vote for the purpose of election of members to the Council of State is not to be equated to the words vote in the legislature. Conduct unconnected to the legislative function of business cannot aspire to be covered by the immunity clauses of the Constitution. The appellant cannot take any benefit or advantage of the Narasimha principle. The prosecution question is not hit by Article 194. There are three judgments, Your Lordship. We have shared it with the court master. One is Pashupati Nath Shukul versus Nemchandra Jain, 1984 to SEC 404.
1984.
We have shared the judgments with the court master. Was a case of disqualification of election to the Rajya Sabha. Paragraph 18, PDF page 16.
Is it here in the compilation?
Yeah, that's right. There are three judgments in the compilation. It is the first one. Pashupatinath Shukul versus
In the first compilation itself, or in the in volume 5?
No, this is we have shared it separately.
19. All right.
It was not shared with the rest of the council.
All right. Here we've got it here now on the screen. 1985 to SEC 404.
Yeah. This is This is 1984 to SEC 404.
How many judges is this? This is 2 judges or 3 judges? 3 judges.
Yes, yes.
Which is the para you want us to see?
Paragraph 18.
You have my iPad, shoot out. Open it from there and show me.
The question was, if you don't take the oath, whether you can still cast a vote in the Article 191 of the Constitution. Will what happened?
Yes.
Yeah. Prescribe the disqualification of membership of the Legislative Assembly is also. Then Article 193 of the Constitution provides for the penalty for sitting and voting before making oath or affirmation. In Article 188 of the Constitution, when not qualified, when disqualified, the penalty being so and so. You'll also skip a few sentences thereafter. The sentence beginning. Now the question is.
Now the question, middle of the
whether the making of oath or affirmation is a condition precedent for being eligible to act as a proposer of a valid nomination for election to the Rajya Sabha. The rule contained in Article 193 of the Constitution stated earlier that a member elected to the Legislative Assembly cannot sit and vote in the House before making oath or affirmation. The words sitting and voting in Article 193 of the Constitution imply the summoning of the House under Article 174 of the Constitution by the Governor to meet at such time and place as the things fit and hold at the holding of the meeting of the House pursuant to the summons and adjourned meeting. An elected member incurs the penalty for contravening Article 193 only when he sits and votes such a meeting of the House invariably there's the interval between constitution of house after general elections also and the summoning of the first meeting of the house. During the interval, an elected member whose name appears in the notification issued in Section 73 of the Act is entitled to the privileged salaries and so. One of them being the right to function elected and elected help us find seat in the Rajya Sabha. Then a few sentences later, this, the election in question does not form part of the proceedings of the House carried on in its meeting.
Where did we get that?
It's
Just
at
a second.
page 418 of the,
Yes,
page
yes.
17.
Yes.
Yes.
Second
That
line.
is the effect also. Secondly, election in question does not form part of the legislative proceedings the House carried on in its meeting. And this is affirmed by other bench of three judges in 1997, 11 SEC 111.
1997.
11 SEC 111. It's just a one paragraph order where it affirms. PDF page 20.
1997. 1997, 11 SEC.
111.
It's not here in this. It's not in the numbers.
This is again three judges. Justice Ahmadi,
Yeah, three, yeah,
Justice Ahmadi, Justice
To
Jagan.
heard the learned counsel for the petition as the Attorney General would attention to the divisional court and so and so. In that case, two questions were raised for consideration. And one of them was whether a person elected as a member of the Legislative Assembly but was not made and subscribed the prescribed oath and affirmation as required by so and so can validly propose the person as the candidate at an election held for filling a seat in the Rajya Sabha. Dealing with this contention, the court examined the provisions of the Constitution and then came to the conclusion, recorded in para 20, the effect that an elected member would not take an oath, but whose name appears in the notification published so and so, can take part in all non-legislative activities of an elected member. The Lordship's further point out, the right of voting at an election in Rajya Sabha can also be exercised by him. This conclusion is based on the premise the election in Rajya Sabha does not form part of the legislative proceedings the House carried on its meeting. Nor the vote cast election is a vote given in the House at any issue arising before the House. 194 or 105 talks about speeches made in Parliament or a vote given in connection with the business of the function or the work of the House, as wide as it should be. So the US case law shows that even, as I said, preparations for your legislative activity are still protected. Speeches made outside the Congress. Give me the paragraph. And the third judgment is Kuldeep Nair. That's no, it's here also in the same volume.
That's volume 7.
It is 2006-7 SEC 1.
What is the PDF page of volume 7?
Page 1.
Page 2. Brother, you can access
36. 126.
You want to read para
372 or 370?
Yeah, that's page 125.
Volume 7.
Good evening. Case of picking the this is correct. And read those two it's in yes, it's to work. So for that. Page 126. 125.
PDF 125.
Paragraphs 372 and 373. Well, on the one hand, it's important that nothing has a chilling effect on the members of parliament to do what they were, called upon to do as elected members. But
Which
of course, there are
paragraph,
certain
which
outer
para,
limits.
Mr. Attorney?
372.
Para 372. Hello.
It is the contention
the same.
of the learned counsel that the same should be the interpretation as to the scope and tenor of the provision contained in Article 194.2 concerning the privileges of the members of the Legislative Assemblies of the state who constitute statewide electoral colleges for electing the representatives of each state in the Council of State under the provisions of Article 84. The Council argued that the freedom of expression without fear of legal consequences as flowing from Article 194.2 should be inured to the members of the Legislative Assemblies while discharging their function as electoral college in Article 84. This argument, though attractive, does not deserve any credence in the context at hand. The proceedings concerning election under Article 80 are not proceedings of the House or the Legislature of the state within the meaning of Article 194. If the elected members of the Legislative Assembly who constitute under Article 80 the Electoral College for electing the representatives of the state to fill the seat allocated to the state in the Council of States. It's noteworthy that it is not the entire Legislative Assembly that becomes the Electoral College, but only the specified category of members thereof. When such members assemble at a place, they do so not to discharge functions assigned under the Constitution to the Legislative Assembly. Their participation in the election is only an account of their ex officio capacity of voters for the election. So the act of casting votes by each of them, which also need not occur with all of them present together, or at the same time, is merely exercise of franchise and not proceeding to the legislature. So it is absolutely conclusive. Just what it plays in two other treatises. Just show me. Losses can go back to my compilation. Part one is about this three judgments of the Supreme Court, and then I have three judgments of the US Supreme Court. I will not trouble Lodge for the timing of the US Supreme Court judgment, but there are about 5 articles and extracts from 2 books. It's serial number 7, called Political Guide to Parliament by so-and-so.
This is your written submission, Mr. Attorney?
No, this is an article. The compilation of my judgments.
Oh, this way, it's not in our, it's in this. The articles which you are referring to.
The other side.
We have not received the compilation.
We also just got it on the email, actually.
Okay. Sorry.
What do the articles say, Mr. Attorney? You are referring to the articles or the foreign judgments?
Yes. These are 2 textbooks. In fact, books on parliamentary practice. One I picked up only for the purpose of showing that if you also kindly turn to PDF 283, 1 paragraph. The second paragraph at page 283. A member is entitled to protection for what may be a slanderous statement when it forms part of a proceeding of the House. What exactly is the proceeding? The proceeding is usually taken to mean the formal transaction or business with the speaker in the chair or in a properly constituted committee. A member will not be subject to the jurisdiction of the ordinary course for anything said in debate, however criminal in nature. He or she may be subject to the disciplinary procedure of the House. Therefore, it is a transaction of business with the speaker in the chair. So that seems to be the position.
In our case, the bribe is alleged to have been
It
given,
has nothing to do with the business of the House.
so there is no immunity attached.
That's right.
Voting for election of the member of the Rajya
The
Sabha.
election takes place entirely
But
outside.
according to therefore the learned attorney's line of submission, that has nothing to do with the proceedings of the House.
What it boils down to is this. In Kuldeep Nair, para 373, your lordships have taken the view that for such a vote, Article 105 or 194 is not attached. 373. So if your lordships accept that, and that's 5 honorable judges, in that view of the matter, this writ petition deserves to be dismissed. This petition deserves to be dismissed straight away because there is no question of any immunity.
There is no immunity at all.
Correct. Whether the judgment is right or the judgment is not right in law, there is no question of any immunity. Now, if that's the view your lordship takes, then the proceedings terminate right here and now. Now, if he manages to distinguish it or otherwise your lordship wants to go into the issue, then I can assist your lordship saying that the judgment needs reconsideration. I have made those bullet points and for your lordship's consideration, because essentially, according to me, the judgment which now becomes majority, it is 2 versus 2 accepted and then concurred by a third honorable judge, Justice Ray. There were 3 issues. On one issue, whether there are public servants, all 3 judgments are unanimous. On the second issue, as to who is the authority to grant sanction, the judgment of Justice Bharucha says, because there is no authority to grant sanction, therefore proceedings cannot be initiated at all. The Justice Agarwal says that if there is no authority to grant sanction, taking cue from Veeraswamy, he says it is the chairman of the Rajya Sabha, and that is concurred by the third judge. But the third judge then does not concur on this issue of immunity and concurs with the other one there. So it's actually quite a fractured kind of, it's 3 versus 2 plus 1 from one judgment and 2 plus 1 from the other. So it's too important an issue to go like that. That's point 1. Point 2, the majority judgment of Justice Bharucha extensively relies on Johnson. Johnson, in fact, subsequently in the United States is distinguished in Brewster. So therefore, then he relies on the dissent in Brewster. And then he does not follow Curry, which is a judgment from the UK, saying it has not been tested in appeal. So essentially, he relies on a judgment which even in the original jurisdiction is no longer being followed, supports it by a dissent, the dissenting view in the subsequent judgment, and then comes to the conclusion that, yes, there is immunity even if a crime is committed. 2 more points. He does not go into the issue as to when the crime of bribe is complete. The crime of bribe is complete even before the man enters the house. Once you accept a bribe to do a particular act, the act of acceptance is complete at that point of time. Justice Agarwal goes into that issue and says that, yes, that's a very important issue. And then there are consequences of reaching that conclusion. For example, if I accept a bribe and then after accepting, I don't vote as Ajit Singh, then I am liable for prosecution. But in case I do vote, then I am not liable for prosecution. So there is quite a contradiction in the judgment.
So, I mean, taking a very narrow view of the matter, we could as well dismiss this petition, this
according to
SLP.
me,
But
yes,
the point is that these issues will still survive to be argued on another, agitated at another point of
Correct.
time. And why
So,
leave the law in the state
the
of
point
uncertainty?
is whether your lordship wants to look into it now. Therefore, this is an occasion to do so. And I feel, subject to what the others will say, that this is a matter which needs a larger. Your lordship needs to look at it. In your lordship's subsequent judgment in Ajit, therefore, your lordships have narrowed it down. And in all other jurisdictions now, the view is that a crime has to be considered under the ordinary criminal. And the purpose of this immunity is only to protect what happens in Parliament, speeches given in Parliament. The purpose of this immunity is not to make a super citizen who is immune
Which is what
from
I
the
said in
ordinary
Ajit.
criminal.
Because Ajit, actually what happened was on the floor of the Kerala Legislative
Correct.
Assembly.
Correct.
Because it's throwing, it was vandalism. But we said, well, this is not, even then we sort of narrowed down the.
According to me, my lord, it's a matter which eminently needs to be
Yes.
relooked. If I read those points which I have made, on that alone, I need not take your lordship through all the judgments reading. I will do that.
Can you just show us your points? Mr.
Yes,
Patwalia?
if your lordship will just have the points. which I
One
have.
second, Mr. Attorney, this is the line, right? That articles which you are referring to are on this
I
particular.
will certainly canvass the proposition that important issues, but then every time there is the largeness of the issue does not mean it has to go before law. Unless on the facts of the given case, there is a conflict of views. And then I just read one more paragraph. While Simra presents.
He said we can dismiss the. Tell him we can't.
I do see Narasimha presents certain internal 2 versus 3, but just want to.
Show me the head note of Kuldeep Nair again.
Because if the appellant has not voted even after taking bribe, that will be a dishonesty beyond corruption. That's a different matter. But we are not getting in that question.
Justice Ramasubramaniam on the previous bench, my lords, made reference to Contract Act and breach of promise, etc. My lords, in a lighter vein, when the same matter came up.
My compilation is one more part because the US law is littered with a large number of examples. I mean, a real interesting spectrum of conduct of members outside the parliament.
So what we do is we just look at the learned attorney's, the last article which he wants to show us, and then we look at Mr. Patwalia's notes. So that,
Sure,
that is,
correct.
We don't have to go to all the underlying judgments because we have to refer it to if we are,
So
if we are
that
with
has,
you,
to be
we
done,
have to refer.
that has to be done by the larger bench. I
But
have
we
a
will see what groundwork you have laid in your notes.
Yes.
I would also like to be heard for 2 minutes before your lordships call upon Mr. Patwalia. Minutes only in response to attorney, and then minutes.
Let's complete with the learned attorney's submissions.
PDF page 292, 291. This is extract from Parliament and Congress, the comparison of the.
The earlier article was at what page? Page 281, I think, right? Earlier one which you referred to as 281?
Yeah.
Now 290?
It's another, page 291 bottom. Last paragraph, PDF page 291.
291. What does it say, Mr. Attorney? A brief overview of the Supreme Court jurisprudence.
In the area of speech or debate protections in Skilburn, it is appropriate to establish the context for litigation testing the validity of an FBI search warrant of a sitting member's congressional office. The Court of Appeals for the District of Columbia Circuit in the case of so-and-so accurately recites the background legal principle of jurisprudence and is quoted here at length. The next page. The clause confers on members of Congress immunity for all actions within the legislative sphere, even though their conduct, if performed in other than legislative context, would in itself be unconstitutional or otherwise contrary to criminal or civil statutes. The purpose of the protection is to ensure that the legislative function the Constitution allocates to Congress will be performed independently without regard to the distractions of private civil litigation or the perils of criminal prosecution. The clause does not, for example, prevent the criminal prosecution of members of Congress for misconduct, even if somehow connected with their performance of official responsibilities. Malfeasance by a member does not fall within the legislative sphere simply because it is associated with the congressional duties. As the Supreme Court explained in allowing a bribery prosecution to go forward in terms of Brewster, where the prosecution established a prima facie case without relying on the member's constitutionally protected legislative speech as evidence, the constitutional protection for acts within the legislative sphere does not extend to all conduct relating to the legislative process, but only to those activities that are clearly part of the legislative, the due functioning of the process. Very beautifully stated. Therefore, while on the one hand, certainly Lordships will see that even, say, the I find this one area where the codification exercise has eluded Congress and legislatures and parliament for a good number of reasons. For if Nasib Rao has to be reopened in a given case where the width of 194.
If you are relying on this extract, this would indicate that Narasimha Rao is wrong.
No, therefore, in a given case where the principle has to be directly tested.
You are on this that look, in this case, it does not strictly speaking arise.
That's right.
But this
I
enumeration,
don't want
this enumeration of the legal position indicates that the decision of Narasimha Rao is wrong.
Correct. Therefore, even US law is.
Then the only question is, should we await it to arise sometime in the future or lay down something?
But provided the question of Narasimha
You must also not ignore that if it also furthers public morality on the part of our elected representatives, then we should not really defer our decision to some uncertain day in the future.
No, therefore,
isn't it?
This case should rest on its own facts. Prosecution must continue. Therefore, the question of 194 does not arise here. That's my submission.
Right. But on the reference, Mr. Attorney, you are then also taking the view which the amicus is taking that a bribe taken for the purpose of.
If the court were to go in an abstract position as to whether.
The CBI moved a review in Narasimha. I have put it in my written submission. They moved a review.
I find the disconnect between the.
Mr. Attorney, in which case your stand has to be clear that you are supporting the prosecuting agency here.
Yes, I say that it has to be prosecuted.
He has to be prosecuted. And should we go into the correctness of Narasimha Rao, you would be also urging that Narasimha Rao is wrongly decided.
I say prosecuted not because Narasimha Rao is rightly or wrongly decided. I said Narasimha Rao has no application to this case.
Right. So independent of Narasimha Rao, it has to be rejected because this was in connection with an election to the House, which is not a part of the functioning of the House. But if you were to go into the correctness of it, the extract which you are relying upon here, you must then say that according to you, Narasimha Rao is wrongly decided if you were to go into it.
Only to show that in what context probably the court will be called upon to look into this, the sweep of 194. Therefore, I don't think this case probably would warrant that.
This case,
that's all.
Got your point.
But otherwise, 194, if the propositions.
You're right, but as a constitution bench, particularly an issue which deeply affects the morality of our polity. We should not, in that sense, not take an opportunity to straighten the law.
But would your lordship always lay down a law only in the context of a certain set of facts which call for an interference by the court? So the set of facts are absent here. Should Narasimha Rao be the abstract revisited? Is the I have reservations about Narasimha Rao.
But we have 4 eminent counsel appearing on this. What better opportunity for the court to straighten the law? Normally you don't want to get into a broader issue of law where, you feel you may not get the correct assistance because then the entire burden is on us. Even there we take up the burden sometimes.
There are 2 concerns here.
But when you have squarely, a conflict between the opposing viewpoints, Mr. Ramchandran is arguing on one side, we have Mr. Patwale and Mr. Shankar Narayan, and we have the Attorney General. We should set the law straight, That this is an ideal case where the Attorney General must also say that, look, please make a reference and set the law straight. Ultimately, this is something which concerns our polity.
Why did he not say that? I think I made that position very clear.
In fact, by citing this, you have indicated where your line of argument will.
I definitely wanted to say so that the state of the law, but that's not mean
Sure.
that I want to flow along with this.
Yes.
Because on the facts of the case, because
Fact, you got your point. That look, here, it was not in connection with legislative business. Therefore, in any case, there's no immunity. This appeal has to be dismissed.
but where the court has to go into the question, what will be the sweep of legislative business? And what conduct which may have a direct or an indirect nexus with legislative business would fall within 194 will be the ultimate matter to be discussed.
Thank you, Mr. Attorney. Let's hear
I-
Mr. Ramchandran for 2 minutes
Yes,
and then
Mr.
we'll call upon Mr. Patwaria.
Yes.
Thank you, Mr.
I was drawing attention to my written submission only apropos what the Attorney General said in his written submission, because I'd only said it orally. Just volume 1 minutes.
All right.
Just 2 paragraphs I want.
Yes, one.
Volume 1.
Which para?
Minutes. PDF page 3, para 4.
One more thing. Good.
Para 4 and para 8. That's all I wish to show. Minister. Only paras 4 and 8. Minister.
4 and 8.
Para 4 is only to indicate the question involved. PDF page 3, volume 1, para 4. The main issue in this case is whether the appellant, a sitting member of the Legislative Assembly, could be prosecuted in a case of alleged bribery, particularly when this matter in no uncertain terms relates to events pertaining to a vote given by the appellant in a capacity as a member of the Legislative Assembly in the background of Article 194(2) and the law laid down in PV Narasimha Rao. Then para 8 minutes. It is para 8, PDF page 4. It is submitted, my lords have got it, it is submitted that none of the contesting parties have ever challenged the ratio of PV Narasimha Rao. On the contrary, both the contesting parties are ad idem that the ratio of PV Narasimha Rao case holds good and should govern the ambit of parliamentary public legislative privileges envisaged in Article 1052 and 194(2) of the Constitution. What is being contested is the applicability of PV Narasimha Rao's judgment. The respondent, this is the Attorney General stand also here, minutes. The respondent CBI believes that the said judgment does not apply in the instant case as the polling for Rajya Sabha election was held outside the House in the lobby and cannot be taken as a proceeding of the House like a no confidence motion. And in support of this, minutes, they rely on P.N. Shukul and minutes Kuldeep Nayyar. When this appeal is argued on merits before the regular criminal bench, minutes, I would be arguing that both P.N. Shukul and Kuldeep Nayyar are clearly distinguishable because P.N. Shukul, neither of the cases involved a question of immunity, whatever be the references to what constitutes a proceeding in the House or not. The question of immunity did not come up for consideration. P.N. Shukul was whether a person who is not yet sworn in as a member of the state legislature can still vote as an elector in the Rajya Sabha election. And minutes, Kuldeep Nayyar, in the context, minutes, there were 2 questions involved. One was domicile. Earlier, you had to be domiciled in that state. That was done away with. Minutes. That's how people from other states stand for Rajya Sabha from other states. That has been upheld. One part. Then this open voting system. It is because of that open voting system that it has come out that I have also not voted for this person. That, minutes, in the context of secrecy of ballot, There, this honorable court holds that this is not part of parliamentary proceedings, so that secrecy is not violated. It was in that context. Neither of these cases involves the question of immunity, therefore clearly distinguishable. And if at all anyone has to challenge the correctness of any judgment, it would be me, my lords, in the appeal, saying if this is your interpretation of Kuldeep Nayyar or P.N. Shukul, then those judgments need to be reconsidered, is what I will submit there, my lords. But the question of Narasimha Rao reconsideration does not arise.
Yes, Mr. Patwale.
My written submission is volume 8.
Come.
Volume 2, capital A. May I?
Yes.
Firstly, Justice Bharucha, for himself and Justice Rajendra Babu, in his judgment relies upon ex parte Wilson and United States versus F. Johnson and the dissenting judgment in United States versus Brewster. This actually distinguishes and waters down Johnson to reach the conclusion that he does. That is, Article 105(2) protects a member of parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or vote given by him in parliament. Apart from this, Justice Bharucha discards the judgment in R versus Curry on the ground that it has not been tested in appeal. Para 142 is, for the first time in England, Justice Buckley ruled in R versus Curry that a member of parliament who accepts a bribe to abuse his trust is guilty of the common law of offense of bribery. The innovation in English law needs to be tested in appeal. So therefore, this judgment relies on ex parte Watson, which is clearly distinguishable. Justice Agarwal distinguishes it. That was actually a proceeding in parliament only. And F. Johnson is distinguished and not followed in Brewster. As against this, 1.2, Justice Agarwal relies upon the view in R versus Curry, supported by the majority view in United States versus Brewster, the subsequent judgment in United States versus Helstowski, both of which consider the judgment passed in F. Johnson and explain it by taking a different view. Justice Agarwal further places reliance on judgment passed by the Canadian court in Bunting and the Australian decision in White and Boston to support his decision. Thus, the judgment of Justice Agarwal follows the international trend, while the judgment of Justice Bharucha still seeks to hold on to a view which was subsequently explained and diluted even in the original jurisdiction. So therefore, in all original jurisdictions, now the view is that this is not a class of super citizens which is immune. In fact, the view is that if you commit a crime, you have to be tried by the ordinary criminal court of the land. That's one point. Secondly, the view of Justice Agarwal carries out and effectuates the real purpose of Article 105(2) of the Constitution, which is to secure freedom for legislative acts, and does not intend to create super citizens who cannot be prosecuted under normal criminal laws. It is important to note that the same was observed by the Supreme Court of United States in United States versus Brewster at para 40, that admittedly the speech or debate clause must be read broadly to effectuate its purpose of protecting the independence of the legislature, but no more than the statutes we apply was its purpose to make members of Congress super citizens immune from criminal liability. That's the point, Lord. The purpose of this clause is to protect the integrity of the legislative process.
by ensuring independence of a legislature of his actions in the legislature. Now, then thirdly, Justice Agarwal examines the matter in hand and holds that any other interpretation of Article 105 would be subversive of the rule of law. The Honorable Judge at para 47 states, an interpretation of the provision of Article 105(2), which would enable a member of parliament to claim immunity from prosecution in a criminal court for an offence of bribery in connection with anything said by him or vote given by him in parliament or any committee thereof, and thereby place such member above the law, would not only be repugnant to the healthy functioning of parliamentary democracy, but would also be subversive of the rule of law, which is an essential part of the basic structure of the Constitution. This issue has not even been considered in the judgment of Justice Bharucha. The real purpose, the point here is, what is the purpose of 105? That real purpose has not been considered at all by Justice Bharucha. In fact, I'll read a couple of paragraphs from Justice Bharucha's view, where he says we have to give it the broadest interpretation. Any nexus, any connection with the bribe and the proceeding is enough to give you immunity. That's not the view, my lord, anywhere in the world today.
So a member of parliament, according to you, should not be proceeded against even criminally for the expression of a view in parliament or the state legislative assembly.
Correct.
Because that would impinge upon the freedom to express views.
Correct.
Without any sense of fear.
Absolutely.
For instance, if you were to be proceeded against for defamation.
Correct.
For a view which you expressed on the floor of the House.
Correct.
That would directly prevent members of parliament from expressing their views in a very candid and forthright manner.
Correct.
But according to you, if you are prosecuted for bribery, this has nothing to do with your legislative, the object of that immunity.
And Vasan was a case where the prosecution was for perjury, that the member in parliament spoke something which he knew to be untrue. There the protection was granted in Vasan, saying that yes, that's a proceeding in parliament. And if he makes an expression in parliament, then he is immune from ordinary criminal laws for that expression made by him in parliament. Now that is quite different and apart from an act like accepting a bribe, which is never accepted in parliament. Now the fourth thing. Fourthly, Justice Agarwal also examines the issue as to when the offence of bribery is complete. The same has again not been examined in the judgment of Justice Bharucha. It is important to consider the observations made by Justice Agarwal at para 50, wherein which it is stated that the offence of bribery is made out against the receiver if he takes or agrees to take money for a promise to act in a certain way. The offence is complete with the acceptance of the money or on the agreement to accept the money being concluded, and is not dependent on the performance of the illegal promise by the receiver. The receiver of money will be treated to have committed the offence even when he defaults in the illegal bargain. For proving the offence of bribery, all that is required to be established is that the offender has received or agreed to receive the money for a promise to act in a certain way, and it is not necessary to go further and prove that he actually acted in that way. This is also very important, because the offence is complete even before the member actually steps into the parliament, let alone perform any parliamentary act. And nothing proves it from the next part, which I have mentioned.
Look at a simple prosecution under the Prevention of Corruption Act. Suppose a Mamlatdar accepts money for mutating the land revenue records. Now, if the acceptance of the bribe or the agreement to accept the bribe is established, you don't have to establish that he actually mutated the land records. What he did,
this is
irrelevant.
This aspect has not even been considered by Justice Bharucha. Now kindly see the next sentence, because that makes the point. Nothing demonstrates this more clearly than the fact that Shri Ajit Singh MP, who abstained from voting, was held liable for the offence of bribery, because the protection granted under 105 of the Constitution can only be granted to those who voted, thus completely proving the point that the offence of bribery is complete on acceptance of the money and is independent of whatever action follows in parliament. So even Justice Bharucha says that Ajit Singh, having accepted the money, did not vote. And because he did not vote, the parliamentary immunity is not attracted to him, and therefore he can be prosecuted, and therefore holds that he can be prosecuted, and therefore further holds that the bribe givers can be prosecuted under 120B because he is being prosecuted. So therefore, this goes to conclusively prove that the offense of bribery is independent of whatever action they had taken in parliament. And this is considered by the subsequent English laws also. Now, my lord, this is on merits. Now, the next. There is also another very interesting and important issue which surfaces upon a reading of the three judgments in P.V. Narasimha Rao's case. Justice Barucha for himself and Justice Babu, Justice Agarwal for himself and Justice Anand, and then the third judgment of Justice G.N. Ray. Three issues were considered by the court. The first issue being as to whether a legislator is a public servant or not. All three judgments are concurring on this aspect, that a legislature is a public servant. The second issue was as to which is the competent authority to grant sanction. As per Justice Agarwal, the chairman of the Rajya Sabha and speaker in the Lok Sabha is competent to grant sanction till provision is made by parliament, and therefore proceedings can be initiated after taking approval. As per Justice Barucha, there is no authority to grant sanction as yet. Therefore, till such time, no proceedings can be commenced against the legislature. On this issue, Justice Ray agrees with Justice Agarwal and says that with the sanction of the chairman, it can be done. However, on the third issue, regarding interpretation of Article 105 of the Constitution and the protection given, Justice Ray disagrees with Justice Agarwal and agrees with Barucha that protection under Article 2 of Article 105 must relate to the vote actually given and speech made in Parliament by a member, and that Article 2 of 105 must be interpreted broadly and not in a restricted manner. Thus, the net result is that on one issue, all three judges are concurring. On the second issue, the second judge agrees with the first judge, and on the third issue, the second judge agrees with the third judge. Therefore, it is submitted that for such an important issue relating to interpretation of a constitutional provision, and in view of the diverse verdict, which is rather fractured, there is a pressing need for the same to be examined by a larger bench. It's a very, the three issues are there, then one judge is agreeing, all three are agreeing on one, then two are agreeing on one, and then on the other two are agreeing. So it's rather quite fractured in that sense also. Then, my lord, next, it's important to note that it's not as if efforts were not made in the past to get a fresh look at this issue. After the judgment was passed in P.V. Narasimha Rao's case, review petition 2210 to 2227 of 98 were filed, which was, however, dismissed subsequently by a bench of 5 honorable judges on the ground of delay of 179 days. The order of dismissal of review petition is reported in 2001, 9 SCC, page 249. It is at volume 5, page 666 of your lordship's paper book. Apart from the above, writ petition bearing 7490 of 99 was filed before this court, challenging the majority judgment in Narasimha Rao's case. This honorable court, by order dated 1st May, referred the same to a bench of 5 judges, noticing a submission regarding maintainability of such a petition. Thereafter, however, that writ petition was dismissed on 18 July 2002, keeping in view the principles laid down in Rupa Ashok Hura. Clearly, the bench of 5 honorable judges would have been of the view that the petition did not meet the requirements of a curative petition. Finally, in this third proceeding now, the matter has again come up in reference before this court. Actually, the review was by the CBI to begin with. The CBI filed a review saying that the judgment needs a fresh look. That review ultimately is dismissed on the ground of delay. Then a fresh writ was filed, referred to 5 judges. Ultimately, it was rejected, saying, after noticing the judgment in Ashok Hura, saying possibly that it doesn't meet the parameters of a curative, and therefore it was rejected. So it's not as if efforts have not been made to get this judgment a fresh look. Now, my lord, the purpose, this is more in the nature of argumentative, my lord, 6.3. I need not read this at the moment, my lord, because this is more on merits and not on the reference alone. Now, if I can show your lordship some paragraphs of the judgment itself to show how the judgments proceed, my lord. If your lordship will have volume 5, part 1. Paging is right. 5.3. The judgment begins at page 531. if your lordship will have first Justice Barucha's view. No?
What page does it begin at?
Yes, ma'am. Para 109.
Ah, yes.
Volume
532.
610 billion.
Yes.
Volume 5.
Yes. So it's at 609. The judgment begins.
It's on 10.
610. Sorry.
Of volume 5?
Volume 5.
610. Actually, I have it at 532 actually. Oh, okay.
Lordships are referring to the PDF, no?
Page 532 is the judgment.
Yes.
At page 610.
Correct. Kindly come to page 613, para 109, where the discussion actually begins. Article 105 is quoted there, Lord. 105 sub Article 2. 107. 105 sub Article 2 says, no member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof, and no person shall be so liable in respect of the publication by or authority under authority of either house of parliament or any report, paper, vote or proceeding. Now the discussion starts at page 109 onwards, and if your lordship will see, come to straightaway page. Various Indian judgments are quoted, my lord. Then your lordship may come to para 117, 118. The question was
PDF 621.
The Attorney General submitted that a proceeding in court founded on the allegation that a member of parliament had received a bribe to vote in a particular way was not a proceeding in respect of a vote that he had given, and therefore the member did not enjoy immunity from proceedings by reason of Article 105(2). He submitted that the immunity given by the Article 105(2) did not cover criminal proceedings. It had been held by the courts of the United States of America, Canada, Australia, and recently England, he said, that a legislator could be proceeded against for corruption. The Attorney General relied upon decisions and reports in this behalf, to which we shall refer. The Attorney General submitted that the immunity given by 105(2) should be interpreted in the light of the times in which we live, and so interpreting it should preclude from its coverage corrupt legislatures. So the question was whether a wide view or a narrow view is to be given. Now, after, my lord, quoting a series of judgments, ultimately, my lord, your lordship may come to para 123, that is page 625, where Curry is cited. Just kindly see para 123. Para 123, very recently, I'm going to read. I'm going to read. Just see para 123. Very recently, in the case of R versus Curry, now this is United Kingdom, my lord, it was alleged against Harry Greenway, a member of parliament, that he had accepted a bribe from Placer, so-and-so and Brooks as a reward for using his influence as a member of parliament in respect of Jurask's application for British nationality. The indictment of the four was sought to be quashed on the basis that bribery of a member of parliament was not a crime, and that in any event, the court had no jurisdiction, for only parliament could try a member for bribery, the matter being not covered by parliamentary privilege. The trial judge, Justice Buckley, did not agree. He quoted the Salmon Commission report He also noted that Lord Salmon, speaking in the debates of the Houses of Lords, had said, after referring to the immunity enjoyed by members of parliament from being prosecuted under the criminal law if they took bribes, that at common law, you cannot be convicted of bribery and corruption unless you are a holder of office. And most of us are not holders of office. Viscount Dilhon had agreed. Buckley did not accept that a question of such great importance could turn on semantics. In his view, to hold that existence of common law crime of bribing a member of parliament depends upon meaning to be given to the word office in this context, as opposed to looking at the principle involved, would not be calculated to commend the criminal law to the public. It should serve. Then, my lord, he notes Chief Justice James Martin in R versus White, that is New South Wales, a legislature who suffers his votes to be influenced by a bribe does that which is calculated to sap the utility of the representative institutions at their foundation. It would be reproach to the common law if the offer of to or of acceptance of a bribe was not an offense. Then, if your lordship may leave the next one, Lord, the same view has been taken in Canada in R versus Bunting. But however, he then goes to discard all of these on the conclusion he reaches. The same view is taken in Canada versus R versus Bunting. I need not read the whole of it, my lord. But if your lordship will then go further at page 628, para 125, Halsbury's laws are also quoted, where clause 36 actually makes them liable under the criminal law. Just kindly see para 125. Halsbury's Laws of England is dealing with members of parliament under the subject of criminal law, evidence and procedure. 36, members of parliament, except in relation to anything in debate, a member of the House of Lords or of the House of Commons is subject to the ordinary course of criminal justice. The privileges of parliament do not apply in criminal matters. That's what Halsbury says. Then 126, my lord, he says, before we deal with the judgment in United States Supreme Court in United States versus Brewster, which lends support to the Attorney General's submission, we should set the speech of debate clause in the Constitution and refer to the judgment in Johnson. Now, my lord, Johnson is distinguished and not followed in Brewster. So now the next few pages are dedicated to Johnson. Then page 630, para 129, the facts of Brewster are cited. And then, my lord, at page 632, yes. And my lord, at 627 at the bottom, my lord, this is page 631. Page 631 at the top, referring to the case of Johnson, Chief Justice Berger. This is Brewster now. This is the extract from the judgment in Brewster. And if your lordship will go to the bottom of the page, the speech or debate clause, your lordship has got it? This at page 631, Placetum F.
Yes.
Just next to Placetum F, the speech or debate clause admittedly has to be read broadly to effectuate its purpose of protecting the independence of the legislative branch. But its purpose was not to make members of the Congress super citizens immune from criminal responsibility. In its narrowest scope, the clause is a very large, albeit essential grant of privilege. It has enabled reckless men to slaughter and destroy others with impunity. That was the conscious choice of the framers. Chief Justice Berger did not discount entirely the possibility that an abuse might occur, but this possibility, which he considered remote, had to be balanced against the potential danger flowing from either abuse or bribery. Then, my lord, it goes on discussion. Para 130, then he starts the dissenting view, which goes on to the next few pages. And then ultimately, if your lordship will come to page 635, para 132. Hundred and 33, 34 are actually the main concluding paras. Hundred and 32, it is noted the judgment in Brewster was followed in United States in Helstokski. Justice Brennan, dissenting expressed the view that indictment in question should have been dismissed, since a corrupt agreement to perform legislative act, even if provable without reference to the acts, may not be subject of general conspiracy protection. That was the dissent. Now 33-34 actually is what he concludes. Broadly interpreting, as we think it should be, Article 105(2) protects a member of parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in parliament. This is too broad. The submission is this is far too broadly stated. The learned Attorney General argued against this broad construction, but the very broad construction is accepted. Now, 133, 134, 135 are the three main paragraphs, my lord, where the learned judge leans towards the broadest possible construction of any nexus is enough to attract the immunity. Now, 133, I have read, my lord. 34. The charge against the alleged bribe takers is that they were party to a criminal conspiracy and agreed to or entered into an agreement with the alleged bribe givers to defeat the no confidence motion by illegal means. I can leave the next few, my lord. Last 4 lines of this paragraph. The nexus between the alleged conspiracy and bribe and the no confidence motion is explicit. The charge is that the alleged bribe takers received the bribe to secure the defeat of the no confidence motion. So some nexus, any nexus, when the offense is complete, has not even gone into the consideration in this judgment at all, which Justice Agarwal will then consider. So the learned Attorney General said, don't give it a broad interpretation. That is, the argument is at para 117. That is rejected in paras 132, 133, 134. He says the broadest possible nexus is enough to attract the immunity. And then 135. While it is true that the charge against them does not refer to the votes that the alleged bribe takers, Ajit Singh excluded, actually cast against the no confidence motion, it may be established deholds these votes, as the Attorney General argued. We do not think that we can ignore the fact that the votes were cast, and in the facts alleged against the bribe takers are true. They were cast pursuant to the alleged conspiracy and agreement. It must then follow, given the expression in respect of, must receive a broad meaning, that the alleged conspiracy and agreement had a nexus to and were in respect of those votes, and that the proposed inquiry in the criminal proceeding in this regard is the motivation thereof. It is difficult to agree with the learned Attorney General that though the words in respect of must receive a broad meaning, the protection is limited to court proceedings, and that is on a slightly different point, my lord. Then, my lord, if your lordship will see, at page 136, 137, at page 636, we are para 137. We are acutely conscious of the seriousness of the offense that the alleged bribe takers are said to have committed. If true, they bartered a most solemn trust committed by them to those they represent. By reason of the lure that they received, they enabled the government to survive. Even so, they are entitled to the protection that the Constitution plainly affords them. Our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate. My submission is that it is not what is being protected is not the guarantee of effective parliamentary participation and debate. It is much more than that which is being protected. Now, 138, important. We draw support from the view we take from the decision in Johnson and dissent in Brewster. So what is the support comes from Johnson, which is dissented in Brewster, not followed in Brewster. And in Brewster, then my lord picks up the dissenting view and not the majority view, which will be picked up by Justice Agarwal. My learned friend is right, my lord, that the word sense of indignation, in fact, is what led to the reference itself, which is recorded. Then, my lord, if your lordship will see at para 142, R versus Curry at page 637, para 142, R versus Curry is discarded because it says it needs to be tested in appeal. Just see para 142. For the first time in England, Justice Buckley, your lordship, for the first time in England, Justice Buckley ruled in R versus Curry that a member of parliament who accepts a bribe to abuse his trust is guilty of the common law offense of bribery. The innovation in English law needs to be tested in appeal. We say this with respect, having regard to earlier English judgments, and we find support in the 22nd edition of Erskine, Mary May's treatise on law privilege, etc. Then that is quoted. Then 143 and 144. Now this is the inconsistency of which emerges from the view taken. 143. Our conclusion is that the alleged bribe takers, other than Ajit Singh, have the protection of 105(2) and are not answerable in a court of law for the alleged conspiracy and agreement. Charges against them must fail. Ajit Singh, having not cast a vote on the no confidence motion, deserves no immunity. So they all took bribes. The one who did not act does not get immunity, and the others who did act are immune. Is also a grave contradiction which arises from the ratio of the law laid down. And because Ajit Singh has no immunity, then the rest also can be prosecuted, is the next paragraph. What is the effect of this upon the alleged bribe givers? In the first place, the prosecution against Ajit Singh would proceed, he not having voted on the no confidence motion, therefore not having the protection of Article 105(2). The charge against the alleged bribe givers of conspiracy and agreement with Ajit Singh to do an unlawful act, therefore must proceed. So the conspirators can be proceeded. So, my lord, this broadly is the view taken by Justice Bharucha. Now, as against this, my lord, your lordship will kindly see now the judgment of Justice Agarwal. It starts at PDF 549. After the preliminary facts and everything, at 557, placetum G, are the questions which are formulated. Yes, yes. 557, the questions are formulated. Now, the two questions arising for consideration can be, does Article 105 of the Constitution confer any immunity on a member of parliament from being prosecuted in a criminal court for an offence involving offer or acceptance of bribe? Is member of parliament excluded from the ambit of the 1988 Act for the reason that he is not a person who can be regarded as a public servant? They're all unanimous on this, and he's not a person comprehended. So on these two here, they are unanimous. Now, if your lordship will see page 558, first, the law in United States is, I need not read the whole of it, my lord. The entire from Tudor and Stuart Kings, the original Bill of Rights, everything is traced, my lord. Then the progress, in fact, your lordships also had occasion to cover all this in your lordship's judgment of that Karnataka case, my lord, there. Kerala, sorry, Ajit. Then, my lord, the English position is considered up to para number 11, that is page 560. Then 561, the Australian position is considered. Then 563, the Canadian position is considered, and all of these jurisdictions lean in favor of the fact that they can be prosecuted under criminal law. The Canadian position is considered. This Bunting, my lord, R versus Bunting, 563 para 15. I can just quickly take your lordship through this, my lord. In the case of R versus Bunting, the defendants had moved for quashing of an indictment for conspiracy to bring about a change in the government of the province of Ontario by bribing members of the legislative to vote against the government. It was argued that bribery of member of parliament is a matter concerning parliament or parliamentary business and is not an indictable offence at common law. and that the exclusive jurisdiction to deal with such a case rests with the Legislative Assembly according to the law and custom of Parliament. Rejecting the said contention, Chief Justice Wilson held, it is to my mind a proposition very clear that this court has jurisdiction over the offence of bribery, as at the common law, in a case of this kind, where a member of the Legislative Assembly is concerned, either in the giving or offering of a bribe, or taking of it, for or in respect of his duties as a member of that assembly. It is equally clear that Legislative Assembly has not the jurisdiction which this court has in a case of that kind. It is quite clear that the ancient definition of bribery is not proper or legal definition. Then other honorable judges also agreed, my lord. At page 564, the United States position is considered. In para 19, Johnson is referred to. Then, my lord, at 565, para 21, Brewster is discussed completely, the majority judgment. And I'm sorry, I hope I'm not going.
No, we are with you.
Since your lordship is only looking at it for the purpose of reference, well, I'm just giving your lordship
the broader perspective
of what is happening. Now, at 566, para 23, then the learned judge says, having taken note of the legal position, and your lordship may take it, all these judgments are on the record. They all are consistent on the point that bribery is an offense, there is no immunity. Now, having taken note, para 23 of the legal position as it prevails in the various countries, we may examine the legal position in India. Then after noticing the position, at 567, para 26, the judge frankly records that this has never come up in an Indian court before. Para 26. If your lordship will see, the question whether a member of parliament can claim immunity from prosecution before a criminal court on charge of bribery in relation to proceedings in parliament has not come up for consideration before the court. It has to be examined in the light of the provisions contained in the Constitution. Now, it is with this preface, my lord, that the learned judge examines it. And then, my lord, 569 arguments of counsel, para 32 is the Attorney General's argument. Yes, just then that is all referred to. Then 575, the judgment in Preble is also referred to. That is arising from New Zealand. Then, my lord, para 41 onwards, that is 572, 576, sorry, 576, the learned judge starts discussing. Though the conclusions are in paras 43, 44, 45, but from para 41, I'll just take your lordships through the learned judges. Para 41 at 576. As indicated earlier, Article 105(2) is in two parts. In these appeals, we are required to consider the first part, which provides that no member of parliament shall be liable in any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof. The immunity that has been conferred by this provision is only on a member of parliament with regard to liability in any proceedings in any court, which would include civil as well as criminal proceedings in respect of anything said or vote given by such member in parliament or any committee thereof. Then, my lord, Mr. Rao has submitted that having regard to the object underlying the provision to secure freedom of speech in parliament to members, the immunity must be considered in a wide sense, just as expression, anything was considered. That's the argument on the petitioner side. Para 43, the Attorney General. The learned Attorney General has, on the other hand, argued that immunity granted under clause 2 of Article 105 is intended to protect a member from liability arising out of a speech made by him or a vote given by him. It cannot be extended to cover the conduct of a member who has received bribe or has entered into a conspiracy to commit the offense of bribery in order to make a speech or cast his vote in parliament. The submission is that the expression in respect of in clause 2 of Article 105 must be so construed so as to ensure that the immunity conferred under clause 2 is only available in respect of legitimate acts of member of parliament, and it cannot be invoked to secure immunity against criminal acts committed by a member in order to make a speech or give a vote in parliament or committee. According to the learned Attorney General, the expression in respect of must be construed to mean for reliance has been placed on decision of this court in state of Madras versus Swastik Taboo Factory. Then, my lord, Tej Kiran Jain is considered. If your lordship will come to page 578, in the middle, next to placetum D, because this is the observation in Tej Kiran after the extracted portion, emphasize the object underlying the immunity that has been conferred under Article 105(2), namely that the people's representatives should be free to exercise their functions without fear of legal consequences. Borrowing the words of Chief Justice Berger, it can be said that this immunity has been granted to protect the integrity of the legislative process by ensuring the independence of the individual legislators. This is emphasized. It cannot be given a construction which would lead to to Article 105, a charter for freedom of speech in Parliament being regarded, as per the phrase used by Lord Salmon, a charter for corruption, so as to elevate members of Parliament as super citizens immune from criminal responsibility. That is Chief Justice Berger in Brewster. It would indeed be ironic if claim for immunity from prosecution founded on the need to ensure independence of members of Parliament in exercising their right to speak or cast votes in Parliament would be put forward by a member who has bartered away his independence by agreeing to speak or vote in a particular manner in lieu of illegal gratification that he has been paid or promised. By claiming immunity, such a member would be seeking a license to indulge in corrupt practice. So this is the crux, my lord. It is no doubt true that a member who is found to have accepted bribe in connection with the business of the Parliament can be punished by a House for contempt, but that is not a satisfactory solution. In exercise of power to punish for contempt, House of Commons can convict a person for custody, etc. My lord, then May's Parliament. Just a few more paragraphs, my lord, I want to show from this judgment, and then I am quite done to say that, in fact,
We'll come back up.
yes, yes. At page 579, para 47, just volume 5, just 4-5 paragraphs from this judgment, not where actually para 47 is the real crux of the ratio in Justice Agarwal's judgment. 47 is where he really lays, is the finale. And then paras 50 to 52 are when the offense of bribery is complete, it's prior. Now, as mentioned 47, as mentioned earlier, the object of the immunity conferred under Article 1052 is to ensure the independence of the individual legislatures. Such independence is necessary for healthy functioning of the system of parliamentary democracy adopted in the Constitution. Parliamentary democracy is a part of the basic structure of the Constitution. an interpretation of the provisions of Article 1052, which would enable a member of parliament to claim immunity from prosecution in a criminal court for an offence of bribery in connection with anything said by him or a vote given by him in parliament or any committee thereof, and thereby place such member above the law, would not only be repugnant to healthy functioning of parliamentary democracy, but would also be subversive of the rule of law, which is an essential part of the basic structure of the Constitution. It is settled law that in interpreting the constitutional provisions, court should adopt a construction which strengthens the foundational features and the basic structure of the Constitution. That is Subcommittee of Judicial Accountability. The expression in respect of precedes the words anything said or any vote given in Article 105(2). The words anything said or any vote given can only mean speech that has already been made or a vote already been given. The immunity from liability therefore comes into play only if speech has been made or vote has been given. Immunity would not be available in a case where speech has not been made or vote has not been given. When there is a prior agreement whereunder a member of parliament has received an illegal consideration in order to exercise his right to speak up or give vote in a particular manner on a matter coming for consideration before the House, there can be two possible situations. There may be an agreement whereunder a member accepts illegal gratification and agrees not to speak in parliament and not to give his vote in parliament. The immunity granted under 105 would not be available to such a member, and he would be liable to be prosecuted on the charge of bribery in a criminal court. This is Justice Barucha also agrees when he lets Ajit Singh go. What would be the position if the agreement is that in lieu of illegal gratification paid or promised, the member would speak or give his vote in parliament in a particular manner and speaks and gives his vote in that manner? As per the wide meaning suggested by Shri Rao for the expression in respect of, the immunity for prosecution would be available to the member who has received illegal gratification under such an agreement for speaking or giving his vote and who has spoken or given his vote in parliament as per the agreement, because such acceptance of illegal gratification has a nexus or connection with such speaking or giving of vote by that member. In the construction placed by Shri Rao on the expression in respect of is adopted, the member would be liable to be prosecuted on the charge of bribery if he accepts bribe for not speaking or not giving vote on a matter under consideration by the House, but would enjoy immunity from prosecution for such a charge if he accepts bribe for speaking or giving his vote in parliament in a particular manner, and he speaks or gives in vote in parliament in that manner. It is difficult to conceive that the framers of constitution intended to make such a distinction in the matter of grant of immunity between a member of parliament who receives bribe for speaking or giving vote in parliament in a particular manner and speaks or gives vote in that manner, and a member of parliament who receives bribe for not speaking or giving vote in a particular matter coming in the House and does not speak or give vote as per agreement so as to confer an immunity on prosecution on the charge of bribery on the former, but denying such immunity on the latter. Such an anomalous situation would be avoided if the words in respect of in Article 105 are construed to mean arising out of. In the expression if in respect of is thus construed, the immunity conferred under 1052 would be confined to liability that arises out of or is attributable to something that has been said or vote that has been given by a member of parliament or committee thereof. The immunity would be available only if the speech has been made or vote has been given is an essential and integral part of the cause of action for the proceedings giving rise to liability. The immunity would not be available to give protection against liability for an act that precedes the making of the speech or giving of the vote by member in parliament, even though it may have a connection with the speech made or vote given by the member, if such an act gives rise to liability which arises independently, does not depend on the making of speech or giving of vote in parliament. Such independent liability cannot be regarded as liability in respect of anything said or vote given by member in parliament. The liability for which immunity can be claimed under 1052 is the liability that has arisen as a consequence of the speech that has been made or the vote that has been given in parliament. That's the crux of the matter. Now, this is further sort of cemented or supported by what is said now in para 50 onwards. The construction placed on us on the expression in respect of in Article 105(2) raises the question, is the liability to be prosecuted arising from acceptance of bribe by a member of parliament for the purpose of speaking or giving vote in parliament in a particular manner or a matter pending consideration before a house, an independent liability which cannot be said to arise out of anything said or vote given by a member of parliament? In our opinion, the question must be answered in the affirmative. The offense of bribery is made out against the receiver if he takes or agrees to take money for promise to act in a certain way. The offense is complete with the acceptance of the money or on agreement to accept the money being concluded, is not dependent on the promise of the illegal, is not dependent on the performance of the illegal promise by the receiver. The Patwari example which your lordship gave. The receiver of the money will be treated to have committed the offense even when he defaults in the illegal bargain. For proving the offense of bribery, all that is required to be established is that the offender has received or agreed to receive money from a promise to act in a certain way. It is not necessary to go further and prove that he actually acted in that way. And the promise to receive an act is not nowhere connected with proceedings in the house. That precedes that. Then, my lord, the offense of criminal conspiracy is defined in section 120A IPC in the following terms: when two or more persons agree or to do or cause to be done an illegal act, an act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. Then the proviso says no agreement except an agreement to commit an offense should amount to criminal conspiracy unless some act besides the agreement is done by one of the parties to such agreement in pursuance thereof. The offense is made out when two or more persons agree to do or cause to be done an illegal act, or when two or more persons agree to do or cause to be done by illegal means an act which is not illegal. In view of the proviso to section 120 IPC, an agreement to commit an offense shall by itself amount to criminal conspiracy. It is not necessary that some act besides the agreement should be done by one or more parties to such agreement in pursuance thereof. This means that the offense of criminal conspiracy would be committed if two or more persons enter into an agreement to commit the offense of bribery. It is immaterial whether in pursuance of that agreement, the act that was agreed to be done in lieu of payment of money was done or not. The criminal liability incurred by a member of parliament who has accepted bribe for speaking or giving his vote in parliament in a particular manner thus arises independently of the making of the speech or giving of vote, and the said liability cannot be regarded as liability in respect of anything done or vote given in parliament. We are therefore of the opinion that the protection granted under Article 105 cannot be invoked by any of the appellants to claim immunity from prosecution. So first, the interpretation of 105, then when the offense is complete. And the second part, in fact, Justice Bharucha does not even deal with it at all from what is discussed from paras 50 to 52. So, my lord, this is basically the essence. Also, if your lordship will have page 586, just before 56, the concluding para, the position in the rest of the world is also considered, and there is a comment on that. 586, just placitum A in the earlier part of the judgment. In the earlier part of the judgment, we have found that for the past more than 100 years, legislatures in Australia and Canada are liable to be prosecuted for bribery in connection with their legislative activities. And with the exception of United Kingdom, most of the Commonwealth countries treat corruption and bribery by members of the legislature as a criminal offense. In the United Kingdom also, there is a move to change the law in this regard. There appears to be no reason why legislatures in India should be beyond the pale of laws governing bribery and corruption when all other public functionaries are subject to such law. We are unable to hold the contention. In United Kingdom, now, my lord, the Bribery Act has been enacted. We have placed it on the record. I have not made it part of my submission for the reason. Under the Bribery Act, public servants are all liable for the offense of bribe. Now, as per this judgment, all our legislators are public servants, which is unanimously accepted by all. So therefore, we did not come across a direct judgment saying legislatures in UK are also public servants, though Curry has been taken forward, and that appears to be the legal position there as well. But the Bribery Act has been enacted, and run up to the Bribery Act. In fact, your lordships, I'm going to cite K. Ajit after this. Your lordships have noticed that entire development over there. And then your lordships have said some 3 paras of Ajit also I'll cite to your lordships. Now, my lord, the third judgment of Justice Ray is at page 609 of this. It's a short order, my lord. I'll just read to your lordships, where he agrees in parts with both the judgments. I have had the privilege, 609. I have had the privilege of reading both the judgments, one of my learned brother, Justice Agarwal, and other by my learned brother, Justice Barucha. Though I respectfully concur with the finding of Justice Agarwal and agree with the reasoning for such finding that 1, a member of parliament is a public servant under section 2C of the Prevention of Corruption Act, and 2, since there is no authority competent to grant sanction for prosecution of a member of parliament under section 19(1) of the Prevention of Corruption Act 1988, court can take cognizance of the offences mentioned in section 19(1) in the absence of sanction. But before filing a charge sheet in respect of an offence punishable under section 7, 10, 11, 12, 15, 88 Act against a member of parliament in a criminal court, the prosecuting agency shall obtain the permission of the chairman of the Rajya Sabha, speaker of the Lok Sabha, as the case may be. I have not been able to persuade myself to concur with the reasonings and findings in the judgment of Justice Agarwal that a member of parliament does not enjoy immunity under Article 105(2) or 105(3) of the Constitution from being prosecuted before a criminal court for an offence involving offer or acceptance of bribe for the purpose of speaking or giving vote in parliament. Article 105 of the Constitution deals with powers, privileges, etc. of houses of parliament, members and committees thereof. Sub-Article 1 of Article 105 makes it evident that subject to the provisions of the Constitution, rules and standing orders regulating procedure of parliament, there shall be freedom of speech. The provisions of Article 1 of Article 105 indicate in no uncertain terms that freedom of speech guaranteed under Sub-Article 1 of Article 105 is independent of the freedom of speech guaranteed under 19 of the Constitution. And such freedom of speech under Article 105(1) is not inhibited or circumscribed by the restrictions under Article 19. In order to ensure effective functioning of parliamentary democracy, there was a need felt that a member of parliament would have absolute freedom in expressing his views when deliberations made on the floor of parliament. Similarly, he must enjoy full freedom of casting vote. The protection to be enjoyed as contained essentially flow from the freedom of speech guaranteed under Article 1 of 105. Both articles complement each other. Lord, then my Lord discusses that. And on the next page, just above placitum E, as I respectfully agree with the reasonings indicated in the judgment of learned brother Justice Barucha, that in the facts of the case, protection under 105(3) of the Constitution is not attracted, but protection under sub-article 2 of 5 is available only to those accused who as members of parliament has cast their vote. I refrain from indicating separate reasons. So he agrees on 2 points with Justice Agarwal and then agrees on the third point with Justice Barucha. While on the first point, all 3 agree with each other. So that's the way how the judgment is. Now, my Lord, your Lordship may also see one more judgment before I make my submission. That is the judgment in K. Ajit. This is volume. This is again volume 5, my Lord, page 1526. The judgment starts. 3 paragraphs I want to read to your Lordships. That is the state of Kerala. The factual matrix is in para 4, where your Lordships have just one paragraph, 1526. On 13th March 15, the then Finance Minister was presenting the budget for the financial year 15-16 in the Kerala Legislative Assembly. The respondent accused, who at the time were members of the Legislative Assembly belonging to the party in opposition, disrupted the presentation of the budget, climbed over to the Speaker's dais, damaged furnitures and articles including the Speaker's chair, computer, mic, emergency lamp and panel, causing loss of 2,20,000.
The incident was reported to the Museum Police Station by the Legislative Secretary. Crime was registered under 447, 427, read with 34 of the Penal Code, 3(1) of the Prevention of Damage to Public Property Act. On completion, then final report was submitted. Then the APP sought sanction to withdraw the case. Then, my lord, ultimately they had lost at all stages. I need not go into the facts in more detail, but the discussion, my lord, on immunities and privileges is at 1538, para 27 onward, the discussion starts. Your lordships notice Article 105, para 27 at the bottom of 1538. Notice Article 105, 194 of the Constitution. Then, my lord, your lordships have discussed it. Then your lordships have at 1540 discussed at the top the position in the United Kingdom. Shall I I need not read the whole of it, my lord. The position is discussed. Then your lordships have concluded at para 44 at page 1542 from the now the conclusion is, from the above cases it is evident that a person committing a criminal offense within the precincts of the house does not hold an absolute privilege. Instead, he would possess a qualified privilege and he would receive the immunity only if the action bears nexus to the effective participation of the member in the house. So the narrow construction, what your lordships have actually leaned towards is Justice Agarwal's view, not the broad, not somehow anyhow. Then your lordships have discussed the position in India from para 45 onwards, and your lordships have discussed this judgment also at page 1545. Your lordships have considered Raja Rampal, the cash for query case also. Page 56. We are governed by a written constitution and therefore the constitution is supreme. That's 56, para 56. At page 1545, the principle which emphatically emerges from this judgment is that whenever a claim for privilege or immunity is raised in the context of Article 105 or 194, the court is entrusted with the authority and jurisdiction to determine whether the claim is sustainable on the anvil of the constitutional provision. The Constitution bench held that neither Parliament nor state legislature can assert the power of self-composition, or in other words, the power to regulate their own constitution in the manner claimed by the House of Commons in the UK or in the UK. The decision therefore emphasizes the doctrine of constitutional supremacy in India as distinct from parliamentary supremacy in the United Kingdom, which is also the view taken by Chief Justice in Brewster. Then, my lord, then your lordships quote this Justice Ripudaman Dayal, para 51-52 on the next page. The scope of privilege enjoyed depends on the need for privilege, why they have been provided for. The basic premise for the privilege enjoyed by the members is to allow them to perform their function as members, and no hindrance can be caused in the functioning of the house. Then again, the next para 52, it is clear. Basic concept is that privileges are those rights without which the house cannot perform its legislative function. They do not exempt members from their obligations under any statute, which continue to apply to them like any other law applicable to ordinary citizens. In fact, this is what Justice Agarwal says, and this is actually the view which your lordships have also taken. Then, my lord, your lordships have gone into the facts of that case. But at page 1549, three more paragraphs I want to read, 72, 73, 74. Para 72, if your lordship will kindly see. Para 72. Tracing the history of the privileges and immunities enjoyed by members of the House of Commons, May makes a doctrinal division of the position in the UK into various phases. However, the standout feature which emerges from the privileges and immunities of members of the House of Commons is the absence of an immunity
from the application of criminal law. This jurisprudential development began in Sir John Eliot, was developed by Justice Stephen in Bradlaugh, and cemented by the UK Supreme Court in Kiter. Kiter, actually, we have attached a lot. Those paras I can give your lordships in a note. I did not read it. It takes it further and cements the position, actually, that they are not immune from ordinary criminal statutes. Then there is a valid rationale for this position. The purpose of bestowing privileges and immunities to elected members of the legislature is to enable them to perform their functions without hindrance, fear, or favor. This has been emphasized by three-judge bench in Lokayukta, Justice Ripusudan Dayal. The oath of office which members of parliament and of the state legislatures have to subscribe requires them to bear true faith and allegiance to the Constitution of India as by law established, uphold the sovereignty and integrity of India, faithfully discharge the duty upon which they are about to enter. It is to create an environment in which they can perform their functions and discharge their duties freely that the Constitution recognizes privileges and immunities. The privileges bear a functional relationship to the discharge of functions of a legislature. They are not a mark of status which makes legislatures stand on unequal pedestal. It is of significance that though Article 19(1)(a) expressly recognizes the right to freedom of speech and expression as inherent in every citizen, both Articles 105(1) and 94(1) emphasize that there shall be freedom of speech in Parliament and legislature of a state. In a sense, 19(1)(a) recognizes an individual right to freedom of speech and expression as vested in all citizens. Article 105(94) speak about freedom of speech in Parliament and state legislatures, and in that context must necessarily encompass the creation of an environment in which free speech can be exercised within their precincts. The recognition that there shall be freedom of speech in Parliament and state legislature underline the need to ensure the existence of conditions in which elected representatives can perform their functions effectively. The duties and functions are as much a matter of duty and trust as they are a right inherent in the representatives who are chosen by the people. We miss the wood for the trees if we focus on rights without corresponding duties upon elected public representatives. Privileges and immunities are not gateways to claim exemption from the general law of the land, particularly as in this case, the criminal law which governs the action of every citizen. It's a very important statement. To claim an exemption from the application of criminal law would be to betray the trust which is impressed on the character of elected representatives as the makers and enactors of law. The entire foundation upon which the application for withdrawal under 321 was moved by the public prosecutor is based on fundamental misconception of the constitutional provision contained in Article 194. The public prosecutor seems to have been impressed by the existence of privilege immunities which would stand in the way of prosecution. Such an understanding betrays the constitutional provision and proceeds on a misconception that elected members of legislature stand above the general application of criminal law. So, my lord, that is what I want to read from here. And ultimately submit, my lord, therefore, that this is a case where a reference is needed to a larger bench. Because one, the judgment which ultimately finds acceptance of the third judge actually proceeds and relies on judgments which are no longer good law in the original jurisdiction, relies on the dissenting judgment. That is point number one. Point number two, my lord,
yes,
it accepts the very wide definition of the provision and says any nexus which is not the correct position in law. The object of the privilege is to be seen to ensure freedom within the legislature, freedom of expression, and not to confer an immunity from ordinary criminal laws. This is para 47 of Justice Agarwal's view. Third, it completely misses the point as to when the offense is complete. Paras 50 to 52 of Justice Agarwal's view. The offense is actually complete much before the legislature goes to the parliament.
And my lord, lastly, as your lordships have also said in Ajit in para 72 on, first para 42, para 44 and then 72 onwards, the international trend is also that legislatures are not beyond the criminal law and law of the land. And therefore, my lord, on these points, I would submit that a fresh look is required and the matter should go to a larger bench.
Yes, thank you, Mr. Patwale. Yes, Mr. Shankar.
Just a few points, I won't take long. It's the entirety of the Jharkhand case revolves entirely on an interpretation of three words in Article 105 and Article 194. Those are the words in respect of. If I can trouble your lordships with that part, because that is the. Lords, I've got
In
four
Narasimha Rao,
copies.
did they summarize their conclusions? I
Yes,
think there's a
yes.
paragraph. Let's just see that. And then.
Court mein abhi liya. Well, Lords, these red copies of the Constitution, I've got 4 more. I'll get you a 5th. I've just.
So I get a second one because of the second constitutional bench.
Bankers should also get one.
Yeah, you will. What I could arrange now, I got.
Don't do it.
If your lordship were just to see Article 105, subclause 2. No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof. I'll pause there. This in respect of is what had to be interpreted by the court. And the cleavage in opinion between the majority and the minority is on how in respect of will be interpreted. So I just want to read, large parts of the judgment have been read by the learned amicus. If I can just trouble your lordship with just one small passage, which is in para 47 of the judgment at page 580, PDF 580. Just one little passage because this is the heart of
PDF page 580 of?
580 of same volume 5, Narasimha Rao's judgment. If I can have your lordship's attention at placitum C, just between C and D. My lords have it? Page 580. If I can read that. If the construction...
579, is it?
580, my lords. PDF 580.
Yeah.
The big numbered page will be 576, but PDF is 580. Yeah, this is para 47, which continues from the previous. Yeah. Somewhere exactly halfway down the page, it says, if the construction placed by Sri Rao, your lordships have that?
Yes.
On the expression in respect of is adopted, a member would be liable to be prosecuted on a charge of bribery if he accepts bribe for not speaking or for not giving his vote on a matter under consideration before the House. But he would enjoy immunity from prosecution for such a charge if he accepts bribe for speaking or giving his vote in Parliament in a particular manner and he speaks or gives his vote in Parliament in that manner. It is difficult to conceive that the framers of the Constitution intended to make such a distinction in the matter of grant of immunity between a member of Parliament who receives bribe for speaking or giving his vote in Parliament in a particular manner and speaks or gives his vote in that manner, and a member of Parliament who receives bribe for not speaking or not giving his vote on a particular matter coming up before the House and does not speak or give his vote as per the agreement so as to confer an immunity from prosecution on charge of bribery on the former, but denying such immunity to the latter. So by the mere act of abstaining from voting, and if he's been bribed to abstain from voting, he would be immune.
As Ajit
He would not be immune, I'm sorry. He would not be immune.
He does not be.
But if he acted and he voted in a particular fashion, he would be immune. Now, this artificial distinction, they say that it's difficult to conceive that the framers of the Constitution meant that. Such an anomalous situation would be avoided if the words in respect of in Article 1052 are construed to
That's
mean.
why Ajit was not granted.
He was not.
immunity.
He was not. In fact, the conclusions your lordships asked, if your lordships come to the conclusion, I'll just come to that. In respect of in Article 1052 are construed to mean arising out of. If the expression in respect of is thus construed, the immunity conferred under Article 1052 would be confined to liability that arises out of or is attributable to something that has been said or to a vote that has been given by a member in Parliament or any committee thereof. The immunity would be available only if the speech that has been made or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. The immunity would not be available to give protection against liability for an act that precedes the making of the speech or giving a vote by a member in Parliament, even though it may have a connection with the speech made or the vote given by the member, if such an act gives rise to a liability which arises independently and does not depend on the making of the speech or the giving of vote in Parliament by the member. Such an independent liability cannot be regarded as liability in respect of anything said or vote given by the member in Parliament. The liability for which immunity can be claimed under 1052 is the liability that has arisen as a consequence of the speech that has been made or the vote that has been given in Parliament. This is the reasoning that the minority adopts, my lords. The conclusions your lordships wanted to see of the majority is at 604. PDF 604. No, sorry. Why is this? Sorry. Para 98, my lords, which is 608, PDF 608. Para 98. Now, these are the conclusions of the minority. On the basis of the aforesaid discussion, we arrive at the following conclusion, and the first conclusion is the one that we are concerned with, that a member of Parliament does not enjoy immunity under Article 1052 or under 1053 of the Constitution from being prosecuted before a criminal court for an offence involving offer or acceptance of bribe for the purpose of speaking or by giving his vote in Parliament or in any committees thereof. There's a one-page concurring judgment of Justice Reyes with the majority. That's the next page, my lords. Page para 101, your lordship will see once again the interpretation of in respect of is there. That's para 101. That's Justice Reyes. After which Justice Barucha's judgment, my lords, starts thereafter for himself and Justice Babu. And if your lordship would be kind enough to come to para 139, which is PDF page 636, 636. Para 140. Mr. Patwale read the next para. I just thought this may be relevant. Brennan J, para 140, your lordship, sir. Brennan J, dissenting in Brewster, said that Brewster had been charged with a crime whose proof called into question the motives behind his legislative acts. He could not only not be prosecuted or called to answer for his vote in any judicial or executive proceeding, but his immunity went beyond the vote itself and precluded all extra congressional scrutiny as to how and why he cast or would have cast his vote a certain way. Neither the senator's vote nor his motives for voting, however dishonorable, could be the subject of a civil or criminal proceeding outside the halls of the Senate. The charge of a corrupt promise to vote was repugnant to the speech or debate clause. It might be that only receipt of the bribe and not performance of the bargain was needed to prove the charge, but proof of an agreement to be influenced in the performance of legislative acts was, quote, by definition an inquiry into their motives, whether or not the acts themselves or the circumstances surrounding them are questioned at trial. Furthermore, judicial inquiry into an alleged agreement of this kind carries with it the same dangers to legislative independence that are held to bar accountability for the official conduct itself. The senator's reprehensible and outrageous conduct, if committed, should not have gone unpunished, but whether a court or only the Senate court might undertake the task is a constitutional issue of portentous significance, which must of course be resolved uninfluenced by the magnitude of the perfidy alleged. These two quotes are relevant because this is effectively what the majority takes and uses as the basis for the entire judgment. See para 141. We cannot but be impressed by the majority opinion in Brewster, but with respect, are more persuaded by the dissent. These two paragraphs are read out. The majority opinion stated that the only reasonable reading of the speech and debate clause was that it does not prohibit inquiry into activities that are casually or incidentally related to legislative affairs, but not a part of the legislative process itself. Upon this construction of the speech or debate clause, it came to the conclusion that a court could investigate whether Brewster had taken a bribe to be influenced in the performance of official acts in respect of his action, vote, and decision on postage rate legislation. With respect, we cannot regard the act of taking a bribe to vote in a particular way in the legislature to be merely casually or incidentally related to legislative affairs. And then they rely on this Library of Congress publication and they approve it, Malods, that the extract is there. And then, Malods, at para 143, your lordships have seen the conclusion that they have drawn after that. Next page, PDF 638. Our conclusion is that the alleged bribe takers, other than Ajit Singh, have the protection of 1052 and are not answerable in a court of law for the alleged conspiracy and agreement. The charges against them must fail. Ajit Singh, not having cast a vote on the no confidence motion, derives no immunity from Article 1052. I ask myself, Manoj, if I were to take a bribe and then have second thoughts, a prick of conscience, and I decide not to vote as the bribe has demanded, I would not have my immunity. But if I were a good boy and I acted as per the bribe and I went and voted in accordance with that, I would suddenly be immune. This absurdity, Manoj, has led to, when this judgment itself came out contemporaneously, there were many criticisms of this and a slew of articles came out. Just one of them by an author, I will just read one sentence from that. In the nearly half century of its existence, this is Mr. Nurani writing in his Constitutional Questions on Citizens' Rights. In the nearly half a century of its existence, few rulings of the Supreme Court incurred such odium, and so deservedly, than that so merrily handed down on 17th April 98 in the Jharkhand Mukti Morcha case. It holds that legislators, MPs, or MLAs who take bribes enjoy constitutional protection from prosecution for their crimes. Lesser mortals, however, who offer the bribes do not. And this in the name of free speech and free vote in the House. If I may draw a parallel, my lords will recall in section 6A, 6 capital A, of the Delhi Special Police Establishment Act, there was the single directive which had been struck down in Vineet Narayan and then they brought it back by way of statute. Your lordships had occasion sitting in 5 to entertain the challenge to section 6A. Section 6A provided that if you are a particular class of officer, a consent is required in order to prosecute you. You created 2 classes of officers, and that was struck down by your lordships. The effect of this judgment is that it says that you are welcome to take bribes provided you are acting in accordance with that bribe as far as the House is concerned. But if any other individual, if a PWG engineer on the street is taking a bribe, there is absolutely no immunity available to him. It is not Article 105 and 194. These provisions are not meant to spread that limited dragnet of protection so far afield that a taking of a bribe for this tenuous purpose is to be protected. And if I may just for a minute take your lordships to one para from Kalpana Mehta, my lords, which is in this same volume. It's at PDF 1325. This is Kalpana Mehta, my lords. PDF 1325. It starts at 1214, PDF 1214. This is the Constitution Bench of my lords dealing with parliamentary committee reports and whether privilege attached to that. I just want to read one paragraph, actually 2 paragraphs. One is para 221, which is at PDF 1325. Do my lords have that?
Yes.
1324, 1325. This is my Lord Justice Chandrachud's judgment as part of the bench. My Lord has para 220, 220.
Yes, that is 1324.
1324, PDF 1324. Now this is also Constitution bench. Para 220 deals with, my lord, summation of PV Narasimha Rao. Para 221 is with reference to the submission of the Attorney General at that point. And I just want to read that para after para 221's extract. At page 1325, just after the extract, your lordships have the view. 1325, second paragraph.
Yes.
The view. Yes, the view of the minority was that the offense of bribery is made out against a bribe taker either upon taking or agreeing to take money for a promise to act in a certain manner. Following this logic, S.C. Agarwal J. held that the criminal liability of a member of parliament who accepts a bribe for speaking or giving a vote in parliament arises independent of the making of the speech or the giving of the vote, and hence is not a liability in respect of anything said or any vote given in parliament. The correctness of the view in the judgment of the majority does not fall for consideration in the present case. Should it become necessary in an appropriate case in future, a larger bench may have to consider the issue. It is our submission that it squarely falls for consideration here because the impugned judgment in the main case deals with this. And, my lords, the defense, Mr. Ramachandran was very fair to disclose, relies on the majority in Narasimha Rao. Now, the majority in Narasimha Rao does not come to his aid if it is overruled. And the conclusion is there for all to see, my lords. Just two small things in addition. One is the judgment in Dawoodi Bora, that's also here, but I'm not taking a lordship's, fairly clear that the only other avenue, apart from concurrent benches referring matters to a larger bench if there is a disagreement, is where it is placed on the administrative side. Your lordship would have seen the orders which were passed in this case. The first order was by a bench of 2. The second order was by a bench of 3. Now that bench of 3 placed it on the administrative side. The last sentence places it on the administrative.
At least 5 judges.
At least 5 judges for consideration. This is only to meet with Mr. Ramachandran's submission that it doesn't call for a reference, or even the Attorney General's. That was a call that was taken on the administrative side to place it before this bench. So now that this bench is already constituted for it, there's no question of reversing it because that's a call that's been taken, and that call is not open to judicial review because it was taken on the administrative side. Now that having been done, my lord, and keeping in mind that between 1998 when this judgment was delivered and now, we have had substantial progresses as far as the law is concerned. In fact, in the same judgment of Kalpana Mehta, while answering the reference at para 271, your lordship noticed the passage of time from the time of independence till now. That's at page 1345, bottom. I won't take more of your time by reading it out, but para 271 and para 274 talk about how the passage of time and the changes that have been wrought. Specifically this sentence, we no longer live in a political culture based on the subordination of individuals to the authority of the state. Our interpretation of the Constitution must reflect a keen sense of awareness of the basic change which the Constitution has made to the polity and to its governance. This is page 1346, the last sentence of para 271. Now, in the 25 years since PV Narasimha Rao's judgment has come, we've had many developments, including the fact of Article 14, Article 1921, individual rights being expanded, public morality, this fell from your lordships. That has undergone a sea change and an expansive interpretation has been given. Also, my lords, in the CVC's case, CVC Thomas's case, which was Center for Public Interest Litigation, with the citation, institutional integrity was coined as an important phrase to be borne in mind when dealing with a writ of quo warranto. Now, if we keep all these phrases in mind, my lords, and consider the developments in law since then, clearly all these principles are now available, perhaps to persuade a larger bench that could be constituted in this case to accept that the Narasimha Rao minority has the correct view and why it should be revisited. I think those developments also need to be borne in mind so that we can reverse the idea that a parliamentarian or a legislator can have some sort of constitutional immunity only because he has acted in terms of the bribe. in the US recently, this Senator Lindsey Graham was questioned. He's been arraigned and he's being questioned about the phone calls that he made during the elections for Georgia. He sought to appeal that, saying it's a privilege which he has under the same Article 1, Section 6 of the US Constitution. That has been rejected by the US Supreme Court, saying, look, we can't expand that at the moment. So they haven't even granted certiorari for that. But it is a subject that is keeping courts engaged in those jurisdictions where we haven't stepped far enough. But in the US, in the UK, everywhere else in the developed world, we have gone far enough to say, as the majority in Brewster did, that you will not have this protection of immunity. India stands out like a sore thumb with having this wafer-thin majority in Narasimha Rao, changing what should be right. Therefore, I join the amicus completely. This matter needs to be referred to a larger bench and this judgment needs to be reconsidered. I'm most grateful.
Sorry. Who are you appearing for?
Yeah, pardon.
Who are you appearing for?
NB Tiwari, intervener.
Intervener.
Yeah.
You are supporting the reference or you are opposing the reference?
Sir, we are accepting the court and we are putting the independent points regarding this matter. Only points.
Do you want us to make a reference or you are opposing the reference?
Are in favor of the reference to the law.
Reference.
So please, sir. Only two points.
2 minutes, yes.
Please. Sir, the point one is that what was the intention of our constitution makers under Article 105 and 194, whether immunity from criminal prosecution for taking bribes or money for vote or speech in House to MP MLAs is creating a different class who are allowed to corrupt the basic structure or the foundation of the democracy. First point is that. And second is that whether in democracy like India, a voter can expect from his elected representative that he should be allowed to take money or bribe for speech or votes in House. Sir, we are deciding from the point of view of the lawmakers from the past decisions, but we are not considering the point of view of our constitution makers and like as the common voter, because in India, we have the constitutional supremacy, not the parliamentary supremacy. So the reference would be the larger bench in this.
Yes, thank you.
Thank you.
Yes, Mr. Attorney.
I mean, I stand by what the attorney has said in the earlier occasion. And not that I remember a catchy phrase of one of the earlier attorney generals of the US, somewhere in the 90s, about the sanctuaries of corruption. That's so Parliament or legislators not become sanctuaries of corruption. That's well taken. But I also said that probably the court is now called upon to sit in review over Narasimha Rao on a particular fact situation, then one can understand that. But we are now thinking in the abstract. The review is over, a curative petition is withdrawn. Now in the abstract, on the facts of this case, I don't think there's need for even applying Narasimha Rao. If I am clear on that, if Narasimha Rao will not even apply, then what is that the question which the court need to formulate and doubt or accept the minority view or go with the majority view? I have not assisted the court either way in my submission. My only, sorry. So if you go entirely by the...
Are you abiding by the stand which was taken by the Attorney General in Narasimha Rao?
let me try that. Now, what the attorney argued in Narasimha Rao is entirely what I certainly as a proposition of law. But I, as an officer of the court, now there is a view taken by the bench. Now, let me just a few preliminary observations. Now, paragraph 74 and 77, the minority view, if you have to go by that and take it as a view of the bench in Narasimha Rao, then the appeal will have to be dismissed because the appellant will have to be prosecuted. I say yes, the appellant will have to be prosecuted on the facts of this case, not because Narasimha Rao is rightly or wrongly decided. Because I started by saying, my observation statement in the morning saying that Narasimha Rao does not fall for application the facts of this case.
But Mr. Attorney General, the impugned judgment of the High Court relies upon the judgment in Narasimha Rao.
No, that's, therefore, they could not have relied upon the judgment.
Defense.
The appellant could not have relied upon the judgment in
Defense of
Narasimha
Mr.
Rao.
Ramchandran also rests on the judgment of the majority.
No, that's how they came, that's how they traveled this length. So
That's right. So we have
otherwise, the matter would have been over somewhere else. So the question of invoking Narasimha Rao does not arise on the facts of this case. It's a very important distinction. Yeah. Whether a narrow view is to be taken or an expansive view to be taken will then be dictated by the facts of a given case. But now, as I said, in the abstract, a narrow view would probably come into the court or a broader view. Because as I see the law, which has grown over a period of time, US, UK, Canada, Australia, I mean, on the one hand, there's a need to keep the integrity of the speech and debate clause, the protection of immunity on the one hand. Same time, an overbroad protection can probably bring in distortions on the functions of a parliamentarians. So on the balance of these considerations, the majority view has taken a particular perspective. So if for the purpose of this case, I'm a little worried whether on the facts of this case, there's a need for a larger reference to a larger bench. The answer would be no. And the prosecution will have to go on. But I stand with the other principle that how do you really expound Article 194 or 105? Maybe there is a case made out for expounding it. But as I said that
the criminal appeal arises from a judgment and order dated 17 February 2014 of the High Court of Jharkhand in writ petition criminal 128 of 2013. Next. An election took place on 30 March 2012 for 2 members of the Rajya Sabha representing the state of Jharkhand. Full stop. The appellant was a member of the Legislative Assembly from a seat reserved for the scheduled tribes and contested as a candidate belonging to the Jharkhand Mukti Morcha. Full stop. The allegation against the appellant is that she accepted a bribe from an independent candidate for casting her vote in his favor. However, according to the appellant, she did not cast her vote in favor of the alleged bribe giver and in fact cast her vote in favor of a candidate belonging to her own party. This having emerged from the open balloting for the Rajya Sabha seat. Full stop. Moreover, the election was rescinded. Moreover, the round of election in question was rescinded and a fresh election was held at which the appellant voted in favor of a candidate belonging to her own party. Full stop. The appellant moved the High Court for quashing the charge sheet and the criminal proceedings instituted against her, relying on the provisions of Article 194(2) of the Constitution. The High Court declined to quash the proceedings on the ground that the appellant had not cast her vote in favor of the alleged bribe giver. Full stop. That has given rise to the appeal. Next. On 23 September 2014, when the proceedings were placed before a two-judge bench, the court was of the view that, to invert commas, since the issue arising, it should be really, don't say into invert commas, that since the issue arising for consideration, into invert commas, is substantial and of general public importance, into invert commas complete, it was required, it should be placed before a larger bench of 3 judges. Full stop. On March 2019, when a bench of 3 judges took up the appeal, it noted that the gravamen of the charge against the appellant is that she had accepted a bribe to vote in favor of a particular candidate in the Rajya Sabha election for Jharkhand. The precise question, as the 3-judge bench noted, as the 3-judge bench observed, was dealt with in a judgment of a constitution bench in PV Narasimha Rao versus State, 1998, 4 SCC 626. Full stop. While 2 judges on the bench into brackets, Justice SP Bharucha and Justice B N Agarwal, Justice SC Agarwal, it was not B N Agarwal, Justice SC Agarwal and Justice G N Ray were of the view that was A.S. Anand, right. Justice A.S. Anand took the view that the protection under Article 1052 and correspondingly Article 194, bracket 2 of the Constitution and the immunity granted would not extend to cases where bribery for making a speech or vote in a particular manner in the House is alleged. The view of the majority was to the contrary. Full stop. The 3-judge bench hearing the present appeal was of the view that, to invert commas, having regard to the wide ramification of the question that has arisen, the doubts raised and the issue being a matter of substantial public importance, into invert commas complete, it required to be referred to a larger bench as may be considered appropriate. Full stop. The matter has been placed pursuant to the administrative directions of the Chief Justice before this bench of 5 judges. We need to take note of that. I mean, give us a PDF page. Just give us the PDF page because that is not shown to us in the morning.
Page 1 minutes.
Page 1.
It's not there on the PDF. It's not there. It's an order dated 15/11/22.
You have a copy of it?
15/11/22. We just see if you have a printed.
Does anybody have a printed copy?
We'll share from her.
Mr. Shankarnad, you may not get it back. Huh?
share one or two printing copies.
Just 2 lines, list on 15.
Thank you. Return with thanks. Yes. We must note at the outset that Mr. Raju Ramchandran, Learned Senior Counsel appearing on behalf of the appellant, submitted that strictly speaking, a reference of the correctness of the decision in PV Narasimha Rao bracket Supra may not strictly speaking be necessary in the facts of the present case. Let's stop. This submission has been also advanced by the Learned Attorney General for India. Let's stop. Mr. Ramchandran, in his note of submissions, as well as in the course of the oral arguments, submitted that none of the contesting parties has challenged the ratio in PV Narasimha Rao Supra. Full stop. On the contrary, it is urged, that the contesting parties are ad idem on the ratio, and what is thought to be contested is the applicability of the judgment. Full stop. The respondent, it is submitted, urges that the judgment does not apply in the instant case, as polling for the Rajya Sabha election was held outside the precincts of the House of Parliament, outside the precincts of the House, the Legislative Assembly, and cannot be taken as a proceeding of the House in a manner similar to a no confidence motion. Let's stop. On this basis, it has been submitted that the reference would not be warranted. Let's stop. At this stage, it would be necessary to note that Mr. R. Venkatramani, the Attorney General for India, has also advanced the same submission, relying on the decisions of this court in bracket 1. मैं आपको citation दे देता हूँ, आप पूरा नाम ले लो. 1984 to SEC 404, semicolon, bracket 2, 1997 11 SEC 111, and semicolon, in bracket 3, 2006 7 SEC 1. Next. Before we before proceeding further, it would be appropriate to note that the judgment that a review petition, into brackets, review petition number 2210-27 of 1998, review petitions, namely, review petition numbers 2210-27 of 1998, were instituted before this court to seek a review to questioning the correctness of the decision in PV Narasimha Rao. Let's stop. The petitions for review were dismissed on the ground that there was a delay, on the ground of delay, in a judgment reported as State bracket CBI bracket SPE versus PV Narasimha Rao, 2001, 9 SCC 249. Full stop. Apart from this, a petition under Article 32 of the Constitution, bracket writ petition civil D-7490/1999, bracket, was instituted before this court. Full stop. By an order dated 1 May 2000 in Center for Public Interest Litigation versus Union of India, 2009 SCC 393, the petition was referred to a bench of 5 judges while noticing a submission regarding the maintainability of the petition. Full stop. Eventually, the petition was dismissed on 18 July 2002 on the ground that the petition did not meet the requirements.
Order only says dismissed keeping in view the judgment.
Was dismissed keeping in view the judgment in Rupa Ashok Hura versus Ashok Hura, 2002, 4 SCC 388. Full stop. In the present case, the bench of 2 learned judges was of the view that, having regard to the significance of the issues raised, it should be placed before a bench of 3 judges. Full stop. In the same manner, the bench of 3 judges was of the view, for the reasons which have been noted earlier, that the entire issue required to be considered by a larger bench. Full stop. Such a decision has been made on the administrative side to constitute a bench of 5 judges for that purpose. Full stop. We are not inclined at this, apart from the significance of the issues raised, which shall be explained in brief a little later in the course of this order, we are not inclined to accept the plea that the correctness of the decision in PV Narasimha Rao, bracket Supra, does not arise in this case. Firstly, it is common ground that the impugned judgment of the High Court relies upon the judgment of the majority in PV Narasimha Rao. Secondly, it is beyond doubt that the defense itself relies on the decision of the majority. Full stop. The correctness of the view which has been propounded in the judgment of the majority in PV Narasimha Rao would have to be inquired into during the course of the hearing of the criminal appeal. Therefore, as both the benches of 2 and 3 judges, respectively in the present case, have opined, it becomes necessary for us to determine prima facie as to whether a reconsideration of the judgment in PV Narasimha Rao is warranted. Full stop. The controversy turns on the interpretation of the provisions of Article 1052 of the Constitution, which full stop, and don't say full stop, and the equivalent article, Article 194, bracket 2, semicolon, the former dealing with the powers, privileges, and immunities of the members of the Houses of Parliament, and the latter of those applicable to the members of the state legislatures. Next. Article 105, bracket 2 provides as follows. वो copy कर लीजिए. The crucial words of Article 1052, the words of the language of Article 1052 indicates that an immunity attaches to a member of parliament, into invert commas, in respect of anything said or any vote given by him, into invert commas complete, in parliament or any committee thereof. Full stop. The expression, anything said or any vote given, would postulate that the immunity attaches in respect of conduct which has taken place, namely, the giving of a vote or upon speech which is made in Parliament or in any committee of Parliament. Full stop. The expression in respect of anything said or any vote given arose for consideration squarely before the Constitution bench in P.V. Narasimha Rao. Full stop. The charge in that case was that the bribe takers had taken bribes to secure the defeat of a no confidence motion on the floor of the House. Full stop. In analyzing the expression, in analyzing the above expression, Justice S.P. Bharucha took the view that Article 105(2) would have to be interpreted broadly, and so interpreted would protect a member of Parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in Parliament, into brackets, paragraph 133 at page 729. The court was of the view that the nexus between the alleged conspiracy and bribe and the no confidence motion was explicit, the charge being that the alleged bribe takers had received bribes to secure the defeat of the no confidence motion. The Attorney General for India, in that case, had urged before the Constitution bench that though the words in respect of must receive a broad meaning, the protection under Article 1052 is limited to court proceedings that impugn the speech that is given or the vote that is cast or arises therefrom. Stop. Noting that the object of the protection was to enable members to speak their mind in Parliament and vote in the same way without the fear of being made answerable, The judgment of Justice S.V. Bharucha contains the following observations. Just copy down. Para 136 at PDF page 636. I'll give you the first three words. It is not enough to the end of the paragraph. Let's stop. The court, Justice Bharucha observed, Justice S.V. Bharucha, the learned judge observed that he was conscious of the seriousness of the offense which the alleged bribe takers were said to have committed, and that by reason of the lucre, L-U-C-R-E, that they had received, they enabled the government to survive. But, the judgment opined, into inverted commas, our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate, to inverted commas complete. Para 137 में ले लो, page 636 को ले लो. However, the court was of the view that the immunity which attached to the other bribe takers would not attach to a member of parliament who had not cast the vote on the no confidence motion and would not therefore be entitled to the protection. Let's stop. The contrary viewpoint of the minority in P.V. Narasimha Rao was espoused in the judgment of Justice Agarwal. Let's stop. The learned judge observed that the expression into inverted commas in respect of would have to be construed in its true perspective. Let's stop. The judgment emphasized that the object and purpose of Article 105(2) of the Constitution is to enable members of Parliament to speak freely or to cast their votes without fear of consequences. Let's stop. In that context, the divergence in view with that of the majority, with that of Justice S.V. Bharucha, emerges from the following extract in paragraph 47 of the judgment. Copy down at page 579 PDF, paragraph 47. Justice Agarwal, in the course of his judgment, also dwelt on the issue as to when the offense of bribery is made out or complete. Let's stop. According to his view, according to the view of the learned judge, the offense of bribery is made out against the receiver if he takes or agrees to take money for a promise to act in a certain way. The offense would be complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the legal promise by the receiver. Full stop. The receiver of the money will be treated to have committed the offense even if he were to default in the performance of the bargain. Hence, the learned judge held that for proving the offense of bribery, all that is required to be established is that the offender has received or agreed to receive money for a promise to act in a certain way. And it was not necessary to prove further that he had actually acted in the way as promised. Full stop. The third judgment in P.V. Narasimha Rao, in P.V. Narasimha Rao's case, was delivered by Justice G.N. Ray. Full stop. Justice G.N. Ray observed that he was unable to concur with the finding in the judgment of Justice Agarwal that a member of parliament does not enjoy immunity under Article 1052 from being prosecuted before a criminal court for an offence involving offer or acceptance of bribe for the purpose of speaking or giving his vote in parliament or in any committee. Let's stop. A reading of the judgment of Justice G.N. Ray indicates that the learned judge concurred with Justice Agarwal in coming to the conclusion that bracket 1, a member of parliament is a public servant under section 2 bracket C of the Prevention of Corruption Act 1988. And 2, since there is no authority competent to grant sanction for the prosecution of a member of parliament under section 19(1) of the Prevention of Corruption Act 1988, the court can take cognizance of the offences mentioned in the provision, but before filing a charge sheet against a member of parliament in a criminal court, the prosecution agency must obtain the permission of the chairperson of the Rajya Sabha, or as the case may be, the Speaker of the Lok Sabha. Full stop. Hence, on the above two issues, Justice J.N. Ray concurred with the judgment of Justice Agarwal. However, on the interpretation of Article 105, bracket 2, Justice Ray concurred with the judgment of Justice S.P. Bharucha, speaking for two judges. Full stop. Hence, the judgment of Justice S.P. Bharucha on the interpretation of Article 105, bracket 2 represents the view of the majority of three learned judges. Next. we may note at this stage that we have heard that besides Mr. Raju Ramchandran, Learned Senior Counsel, and Mr. R. Venkatramani, Learned Attorney General for India, we've also heard Mr. P.S. Patwalia, Learned Senior Counsel, who has been appointed as a amicus curiae to assist the court, and Mr. Gopal Shankar Narayan. Intervener के लिए भी नाम दे दीजिए उनका. Next. We are inclined to agree with the submission of the learned amicus curiae and Mr. Gopal Shankar Narayan, Learned Senior Counsel, that the view which has been expressed in the decision of the Constitution Bench in P.V. Narasimha Rao requires to be reconsidered by case maybe the state legislature must be free to express their views on the floor of the House or to cast their votes either in the House or as members of committees of the House without fear of consequences. Full stop. While Article 19(1)(a) of the Constitution recognizes the individual right to the freedom of speech and expression, Article 105(2) institutionalizes that right by recognizing the importance of the members of the legislature having the freedom to express themselves and to cast their ballots without fear of reprisal or consequences. Full stop. In other words, the object of Article 105(2) or Article 194(2) does not prima facie appear to be to render immunity from the launch of criminal proceedings for a violation of the criminal law, which may arise independently of the exercise of the rights and duties as a member of Parliament. Secondly, in the course of his judgment, in the course of his judgment in P.V. Narasimha Rao, Justice S.C. Agarwal noted that if the construction in support of the immunity under Article 105(2) for a bribe taker were to be accepted, comma, a member would be liable to be prosecuted on a charge of bribery if he accepts the bribe for not speaking or for not giving his vote on a matter under consideration on a matter under consideration before the House, but he would enjoy immunity from prosecution for such a charge if he accepts the bribe for speaking or giving his vote in Parliament in a particular manner, and he in fact speaks or gives his vote in Parliament in that manner. Full stop. This anomaly, Justice Agarwal observed, would be avoided if the words in respect of in Article 1052 are construed to mean arising out of. In other words, in such a case, the immunity would be available only if the speech that has been made or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. Semicolon. Bracket. Thirdly, the judgment of Justice S.C. Agarwal has specifically dwelt on the question as to when the offense of bribery would be complete. Full stop. The judgment notes that the offense is complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the illegal promise by the receiver. Full stop. The receiver of the bribe would be treated to have committed the offense even when he fails to perform the bargain underlying the tender and acceptance of the bribe. Full stop. This aspect bearing on the constituent elements of the offense of a bribe finds elaboration in the judgment of Justice Agarwal, but has not been dealt with in the judgment of Justice S.P. Bharucha, in the judgment of the majority. Full stop. We have already noted above that the efforts to have the efforts in seeking a review of the judgment in P.V. Narasimha Rao and later in proceedings under Article 32 of the Constitution did not bear fruit. Full stop. One of us, into brackets, while delivering the concurring opinion for a constitution bench in Kalpana Mehta versus so and so, page 12144, had occasion to observe that the correctness of the view in P.V. Narasimha Rao would fall for reconsideration in an appropriate case in future, should it become necessary to do so. Let's stop. For the above reasons, prima facie at this stage, we are of the considered view that the correctness of the view of the majority in P.V. Narasimha Rao should be reconsidered by should be considered by a larger bench of 7 judges. But above all, it must be noted that the purpose of Article 105(2) and Article 194(2) is to ensure that members of the Parliament and of the state legislatures are able to discharge their duties in an atmosphere of freedom without fear of the consequences which may follow for the manner in which they speak or exercise their right to vote on the floor of the House. Let's stop. The object clearly is not to set apart the members of the legislature as persons who wield higher privileges in terms of an immunity from the application of the general criminal law of the land, which citizens of the land do not possess. We accordingly request the Chief Justice, the registry, to place the paper before the Chief Justice for constituting a larger bench of 7 judges. Okay, this part I also said that they should.
My only concern was that the appellant does not get the benefit of this long reference because the prosecution, the long pending prosecution, and then
Sorry.
the appellant in this case ought not to get the benefit of this.
Let it be.
That's my concern. It's all.
What we'll do is,
Yeah.
we have heard this substantially. In all probability, we'll constitute a bench in the next week or 2 and we'll get another bench of 2 judges and we'll resolve it. Because there's no point in again now putting this in the whole loop.
Correct.
Because you've all argued for such a long time, the learned attorney has argued.
Yes.
So I think what we'll do is we'll just, we'll notify the bench.
We are right on the question that it doesn't get a benefit of Narasimha either way.
Yes.
Then why should it hang on here?
I think what we'll do is I'll try and constitute a bench in the next week or 2. And because really, I mean, all the pleadings are complete, everything is here before us. We'll resolve it once and for all. Sorry?
Then there's a set of questions that
You'll have to get 2 more of these, yes. I can share one of mine because I have one at home now.
Then that will be constitutional understood by Malayan. No, then the question to be framed, to be placed before the larger bench, then is only the question of correctness of the majority view, or because then you open a canvas too wide.
So we'll say only the correctness of the majority view on the interpretation of Article 105
Therefore, your lordship would go into the interpretation of the article. I mean,
So that would open up a large canvas.
Yes.
7 judges, I mean, we must open up a large canvas. 7 judges is for that.
And the amicus may be requested to continue to us 7 judges.
Please do continue.
I'm not going anywhere now.
You know, Mr. Attorney, what will happen is if you were to lose this opportunity, I mean, we would have, the easiest thing is to close it because we would have closed it in 5 minutes.
Correct.
But, you know, God knows when this opportunity will arise before a constitution bench in the future to, I mean, we may still accept the contrary viewpoint and come to the conclusion that on the balance, you know, Justice Bharucha's view was right. It was a more conservative view. He felt that, look, that's the correct view. I mean, we may still come to that conclusion, but to even reconsider this may probably take another 2 decades, you know, because who knows which case will arise again for us to. So we shouldn't allow an opportunity to go by without on such an important issue which concerns our polity.
It's the court, but only I want to have that outer limits of expanding. Sometimes the inclination of the court to go a little beyond what may be necessary to look into.
She itself is very limited only.
That's
just on the construction of
very
194.
limited question. Because as I said, even today, no, I think Parliament has enacted a law on this immunities and privileges. Because there's a subject where certain
if a person accepts
will always
the bribe,
elude.
if a person accepts the bribe and votes or abstains from voting, then immunity. If a person accepts the bribe and doesn't fulfill their bargain,
if he abstains, he's punished for that.
If he abstains,
he's punished.
That may be another dimension of cheating or dishonesty.
It turns the whole article on its head, actually. Then you are not giving immunity for anything.
To be or not to be.
That is the key part of it. You know? That is the key part. Otherwise, if you just look at the words in respect of, there are a number of judgments that say in respect of must be construed very broadly.
Yes, yes.
Whether in commercial law or in the constitution itself. But this part really is a special issue which arises in relation to Article 105.
To vote or not to vote is a question.
To ditch or not to ditch.
Thank you. Thank you very much, Mr. Patwalia, Mr. Shankaran, Mr. Attorney, and Mr. Ramchandran. Thank you so much.
Would my lords be convening?
We missed you in Article 370 though.
Would my lords be convening for the reconvening for the regular matter?
No, I think with just 15
Because I had a
minutes left.
difficulty in 101, I can mention that tomorrow morning.
You can mention the
please have it next week. I can.
You can just ask a junior to mention if you're not in court tomorrow. No problem.
I had a difficulty after an hour. It's 101.
No problem. Just ask if you are in difficulty, ask your junior to
come in.
I had a request in 102, same request, my lord.
Because provided people after you keep us busy for the rest of the day. Thank you.